hearing you shall be heard. God bless the great state of Ohio and this honorable court. You may be seated.
Today's date is November the 8th, 2024. This is the morning docket of the Lawrence County Municipal Court. I'm Acting Judge Brian Cremines. We're going to be calling the review hearings first. So if you've got a review hearing, when you hear your name called, come up and to the table on your right.
Amber Mead, Amber Billups, Haley Blake, Danielle Bryson, Naaman Cox, Buddy Hardy, Thomas Jones.
Ma'am, you need to mute your microphone. Thank you. All right, Amber Billups.
I'm Amber Mead.
Amber Mead.
Oh, I apologize.
I thought I gave you that
I
phone.
don't think you handed it to me. I've got some wine. Well, Ms. Mead, it's alleged that you failed to appear for a review hearing some time ago. Your case has essentially been concluded at this point, but if you're admitting that you failed to appear, and I know everything's paid, then I'll be concluding your case today. Do you admit or deny that you failed to appear?
Yeah, I give my old man at the time the money to come pay it and told me he did, and I didn't find out until recently that happened because he lied to me, so I apologize. I just found out and come over here today to settle this, so.
Okay. I don't believe that I know that they've already recalled the warrant. I don't believe that there was a warrant fee that went on, but I'm going to complete your case and order that there's no warrant fee on this case. So your case is completed, disposed of, and you're entirely finished.
Thank you so much.
Thank you. Amber Billups. All right, Ms. Billups, looks like just wanted a report from Hometown Recovery. Ms. Billups, that's a really good report. Looks like you only owe, other than completing your treatment, you only owe $270 on the case. I'm not particularly concerned about the $270 right now. I want you to focus on your treatment. You're doing a fantastic job.
Can I say something?
Sure.
I'm sentenced and I have an underlying sentence of a year. I really like this program and I've had my monitor on for 3 months. I want this for myself.
Good.
Could we please try without the monitor? Because we don't get visits there, we only get passes. And I'd like to be able to see my dad and stuff. We get like 2-hour daily passes. But I mean, if I messed up, it was on me anyways. But I'm not going to because I really like this. And this monitor is keeping me from doing the whole program.
Here's what I'll do. I think that's probably a decision that should be made by Judge Capper. I will make a note. I'm going to set you another review first, and then I'll make a note in the file that you're going to request that from him so that he has an opportunity to review it.
That, or if you'd at least approve, because I had to ask you guys if I would at least be approved to take my 2-hour daily passes. It would be within Ireton. I mean, I have the monitor on the whole time.
That would be, I guess, I'm not sure if you're on, that would be up to your provider at that point. As far as that goes, it doesn't, I don't think you're ordered to be there at Hometown, and you're ordered to follow their treatment recommendations and the like, and the GPS to make sure that you stay. If they're okay with it, I don't have a problem with it as far as that goes, as long as you're continuously monitored. And I'm going to set you a new review hearing December 13th.
Thank you, Your Honor.
Thank you. Haley Blake. Haley Blake.
Your Honor, she didn't check in this morning. She was not here for community service on 9/27.
All right, the failure to appear. Bench warrant issued. Daniel Bryson. All right, this is State of Ohio versus Daniel Bryson, TRD 21-2208 A and B, and TRD 19-3468. All right, Mr. Bryson, it looks like on one case, it's a 21 case, you owe $575, and nothing has been paid on it. And on the older case, you're ordered to do 30 hours of community service. None of those have been done, but you've made some payments. Looks like there's $165 owed on it, and you made a payment last month. Do you have a payment to make today?
I do. I also did some community service, but I'm doing it out of Kentucky.
Okay.
And I didn't have a paper. It was supposed to be faxed
Your Honor,
over.
if I may, on 10/18, he was ordered to have some community service done before his next hearing. He did tell me this morning that he has done community service. I sent them our paperwork, and they're supposed to fill it out and fax it back to me.
Okay.
But I do not have it at this time.
Well, we're going to know by the next hearing. Set another review hearing for December 13th at 9 a.m. for review. And how much of payment were you planning on making today?
I can make normal payment. I make like 30, 40 bucks. I know there's two separate cases that I have fines on, so that's probably why the other case doesn't have any payments to it yet.
Yeah, that portion I'm not worried about, but these cases are fairly old. I mean, this is a 2019 case that your fines are going towards now, and there's no community service. Well, you may have community service done, but...
Correct. I understand.
We're talking a 5-year case.
Yeah. No, I understand.
So I don't want to have to put you in jail.
No,
So
I'm
I
good.
need you to get this completed.
I'm doing it as we speak.
All right, we'll see you back on December 13th. Raymond Cox. This is State of Ohio versus Raymond Cox, CRB 23569, PRC 213062 A and B, PRC 221663 A, B, C, D, and E, and PRC 211917 A and B, CRA 21500. All right, Mr. Cox, it looks like I've got some. Are you currently in treatment? Or did you complete?
I completed.
Okay. So, one case, looks like you owe $235.
Your Honor, if I could save you a little bit of time, I owe like $1,800 and some total.
Okay.
I'm working on that.
Yeah, $18.95 looks like. Still have a lot of outstanding community service as well. Is there a reason you have to do community service?
Well, is that one day that we did the dumpster thing? Is that,
You got credit for that.
okay. That was the last time I completed any community service. That's been 2 or 3 weeks ago, I believe.
Okay, are you currently working?
Yes.
All right, where are you working at?
East Lynn, West Virginia.
Okay. Well, I need to see some movement on this. I'm happy and thrilled that you completed your treatment.
I'm in my work clothes today. I mean, I haven't, this is what I wore yesterday. I haven't even made it home.
I understand. And I'm happy that you're working, and I'm happy that you're doing well, but we've got to start digging out of this hole. There's a lot of old cases, and so whether it be you can work it off through community service.
I'm also cooperating with Jackson right now, so I'm it's really hard for me to get a day off for both places to do things like court and whatnot.
Well,
Very inconvenient for me to get here, but I do it for myself, I know.
But you put yourself in this position. It doesn't, and because you're doing better, doesn't mean it necessarily goes away. You know, we want to see you do well. Now, I'm not going to put you in jail as long as you're making an effort, but I just got to see some effort and see that you're moving forward on these. So I'll set you another review hearing. It'll be December the 20th.
9 o'clock.
I am. Buddy Hardy?
Thank you.
Thank you. All right, this is State of Ohio versus Buddy Hardy, PRC 23532, ABCD, CRB 23287, CRB 22600, PRC 1870, and CRA 1864. I was just handed a drug screening, which I believe it's a new drug screening. Okay. All right.
They were running a little behind this morning, so they couldn't get you a, whatchamacallit, like a dossier or whatever.
Well, the drug screen is good,
Yeah.
as far as that goes, but, Hardy, we gotta start working through some of these cases. It hasn't really been,
I was ill and had an excuse because I had sinusitis and I couldn't even get out of my bed for 7 days. I couldn't open my eyes because all the pressure. I couldn't touch my face. It hurt so bad. You know what I mean? And after it went from there, it moved down to my chest, and I'm just now able to breathe and feel like a normal person again.
are you presently working?
No.
You're not?
I have no transportation. I live out by Cold Grove Elementary School. I was riding my bike to the shelter, but I'm going to the wound center for my foot because it busted open again. You know what I mean? So,
Well, I'm going to give you a little more time today, but I'm hearing a whole lot of excuses, and I know our probation will work with you as far as setting you up somewhere closer to where you're at, but these cases have got to be moving or we're going to have to continue my jail time. So I need you to start doing some work here on these. We're talking, we got cases going all the way back to 2018.
that's because I was in jail. I just got out. I've only been out 3 years.
Taking you in custody. I'm not.
What did I do, sir?
Disrespectful, you're contempt, you're going back to back. Thomas Jarvis. All right, Mr. Jarvis has failed. This is State of Ohio versus Thomas Jarvis, PRC 23972A and B. Time's now 10:04 a.m. Mr. Jarvis was slated to be here at 9 a.m. He has failed to appear. They've been trying to issue.
William Rice, Charles W. Ross, Travis Salyers, J.B. Welch, Matthew White.
William Rice. William Rice.
Did not check in, Your Honor.
Thank you. The State of Ohio versus William Rice, hearing 20-2404. Time is now 10:04 a.m. Mr. Rice was to be here at 9 a.m. for review. He has failed to appear with the bench warrant issue. Charles Ross. State of Ohio, Mr. Charles Ross, CRB 378. All right, Mr. Ross, it looks like you got your community service completed, and you're down to $260 here. It looks like the last payment was on 10/16. Do you have a payment today?
No, I'm gonna pay for it Monday. I gotta pick my paycheck up here today.
Okay, how much are you planning to pay?
I'm probably about 75.
All right. You can also work some of that off on community service if you wish. If you have some extra days, you can save yourself some money.
I don't really ain't got no way. I work with trustees almost every day.
Okay. I find that you've made an effort here. You'll be back on 12/20/24 at 9 a.m. for review.
When was it?
December 20th,
December 20th.
9 a.m. Thank
You
you.
have a good day.
You too. Travis Salyers. State of Ohio versus Travis Salyers, CRA 2418, CRB 2420. Just handed a report from OVP Health. It's a fantastic report. Looks like you've done some community service since you were last here. You're down to 6 hours community service left, so you've got 1 day left at $145 is all you've got left to wrap this case up. Since you've done such a good job, I'm going to give you set your review a little further out.
Thank you.
And we're going to go to January 27th at 9 a.m. Hopefully, you'll have it completed by then. If you got everything completed by then, in case of this be completed, you won't have to appear.
Cool.
All right.
Thank you very much.
Jamie Welch.
Yes, sir.
All right. This is State of Ohio versus Jamie Welch, CRB 21-357, PRC 18-3432 A and B, PRC 14-1184, PRC 14-11. Okay, it's just the same case number. All right. Ms. Welch, on one case, it looks like you've got $305 left on it. Nothing's been done. That's the newest case. Same thing on the TRC 18 case.
I have a payment today, Your Honor.
Okay. And I see your last payment was on 10/7. How much you planning on paying?
$40.
All right, I'll set you back on December 20th to review 9 a.m.
Thank you, Your Honor.
Thank you, Ms. Welch.
Have a good day.
You too. And Matthew White.
Yes, sir.
This is State of Ohio versus Matthew White, CRB 23-576 A and B. Just handed an update report. That is an excellent report, Mr. White. I'm more concerned with your recovery right now than I am about anything going on with, as far as what's over on the case, but I don't see.
Well, I've now advanced in the program and I'm allowed to seek employment now, so.
That's fantastic.
Yes, sir.
I'd say it's one of the better reports I've seen in a long time.
Thank
so
you.
I'm really encouraged by that. I'm gonna have you back December 20th for review at 9 a.m.
All right, buddy, thank you very much.
Thank
State of
you.
Ohio versus Thomas Jarvis. Thomas Jarvis.
All right, this is State of Ohio versus Thomas Jarvis, PRC 23-972-83. Mr. Jarvis was called earlier due to the late getting here. So I don't believe the warrant's gone out, but I'm going to recall the warrant. Mr. Jarvis, it's an encouraging review. You've done 12 hours community service since the last time we were here. You're down to 24 hours, so you're down to about 4 days left. And you're down to only $265 left on the case.
Okay.
So you finish those 4 days. If you want to work off, you can work off probably most of the rest of them on community service as well.
Okay.
So,
Thank you.
and it's an excellent treatment report as well. So I'm going to, because you've done so well, I'm going to set you back on January 27th for review at 9 a.m.
At 9, you said?
Yes, sir.
Okay, thank you, sir.
Thank you. All right. The next group of cases that we're going to call are arraignments and first appearances on cases. When you hear your name called, come up to the table on your right. We're going to go through the charge. I'll read the charge, inform you of the possible penalties to the charge or charges, and I'm going to be asking for a plea from you. You can enter pleas of guilty, which means you're admitting the violation. You can enter a not guilty plea, which means you're denying that the violation occurred at this time. Or you can enter a no contest plea, which means you're not admitting the violation, but you're not contesting the facts surrounding the violation. And I can find you guilty if I think the state would have enough evidence. If you're unsure of what you should do, you should enter a not guilty plea because it preserves all your rights before the court. You have certain rights before the court. You have the right to remain silent. We're recording everything in here. If you say something that is against your interest here on audio recording, it's recorded and the state can then use that against you in your case. You have the right to have an attorney, and if you can't afford an attorney, the court will appoint one for you, but I will have to assess your income and the like to determine whether you would qualify. You're entitled to have reasonable bail, and you're entitled to make the state prove each and every element of the offenses that are charged beyond a reasonable doubt. Call the first case.
State of Ohio versus Matthew J. Wilson, case number TRD 24-2278, A and B.
All right, this is State of Ohio versus Matthew J. Wilson, TRD 24-2278, A and B. Mr. Wilson, it's alleged that on or about November the 6th, 2024, in Perry Township, you were operating a motor vehicle on a suspended driver's license, the violation of ORC 451011. That is a misdemeanor of the first degree, maximum penalty is 180 days in jail, and a $1,000 fine. It's also alleged that you had expired tags. That is also, or that's a minor misdemeanor. Maximum penalty is $150 fine and court costs. And it looks like the allegation was they were expired on September 1st. How do you wish to plead?
Not guilty.
Okay, I'll accept your not guilty plea. Are you wishing to have an attorney in this matter?
I'm not sure. Sorry.
Are you wish to be considered for a court-appointed attorney?
Yes, attorney, yes, I guess.
Okay. Are you working?
Yeah,
And how do you, are you paid hourly?
yes. I mean, no, I'm a school teacher, salary.
Okay. Well, to assess you for an attorney, I'd have to know your kind of your annual salary.
Oh,
What's your, what do you make per year?
like 60,
Okay. Do you have any dependents?
no,
Okay. Yeah, you're not going to qualify for a court-appointed attorney.
yeah,
You're free to have an attorney if you wish, but you have to hire one on your own
okay.
on this matter.
Yeah, I was unaware that whenever the officer pulled me over and said that my driver's license were suspended, I was not aware of that. And so he couldn't pull it up to find the reason. And so he said, call the DMV. I called the DMV the next day, yesterday, and it said it was an insurance verification issue. And so I gathered all of my information, sent it to the DMV. Then they realized that on my insurance and my registration, there was a two-letter discrepancy. And so the insurance company had my wrong VIN number on my insurance than the DMV had on my registration. And so yesterday, the insurance had to get an underwrite on that, fix that, and then send it over to the West Virginia DMV to get that. And then also yesterday, I've got my license renewed as well,
Okay.
my tax.
If you want, Mr. Hill, what are your thoughts on this? If you want to take a look at his information.
There's my old card that has the old number, and then there's the new card they made yesterday with my new VIN number that they had the discrepancy on. Oh, and here's my new registration.
It does look like the VIN was, one of these was incorrect. Yeah, I mean, this is a situation that we would probably be willing to dismiss the charge once we know that his license has been reinstated.
Okay. Yeah, today the insurance company was doing all the underwriting from State Farm to send to the DMV, and then once they get that, then they said it would, then they'd be able to reinstate my stuff. So the DMV was just waiting on the underwriting from the State Farm insurance company to send over the stuff.
Do you know how long it's going to be before you have it straightened out?
The State Farm said that underwriting would take 3 to 4 days to them to send it to the DMV, and the DMV yesterday in Charleston said as soon as they received that email from that, it would just be a thing of just calling them back and paying the driver's license restate fee to reinstate my driver's license, the fee or whatever, once they received it from.
Why don't we do this, Mr. Field? You're a teacher, and I know you're probably missing work to be here.
Yes, sir.
For this, would a 4 o'clock traffic court date work better for you on that, since the state's indicating that once you're reinstated, there's going to be a dismissal? I presume you wouldn't have an issue with that.
No, that'd be great.
Okay. Even though this is technically, I think, as charged as the M1, I don't know that it really meets that definition anyway. Why don't we do this? Mr. Wilson, I'm going to set you on Tuesday, November 26th. For a pretrial at 4 p.m. That's our traffic court docket date. And I will note dismiss if your license is reinstated. Thank you.
Oh, thank you,
See
sir.
back on November 26th at 4 o'clock.
All right, thank you, sir.
Thank you.
State of Ohio versus John D. Lawler, case number TRD 24-2273.
It's the State of Ohio versus John D. Lawler, TRD 24-2273. Mr. Lawler, it's alleged that on or about November the 2nd in Perry Township, you were operating a motor vehicle on a suspended license. That's a violation of Ohio Revised Code 4510.111. That is a misdemeanor of first degree, maximum penalty, 180 days in jail, $1,000 fine. How do you wish to plead?
I plead not guilty, but I have paid the forfeitures on the, what led up to the suspension, but also the time of this citation, I did not have, I have not received anything from B&V or the Court of Portsmouth. I don't know when they supposedly mailed out the notice that they suspended my license, but I had no acknowledgement of it at the time of citation.
Let me ask you this, have you done anything to get your license straightened out at this point?
Beg your pardon?
Have you done anything to get your license straightened out at this point?
Yes, I got the both the release of forfeiture and the reinstatement fee receipt from BMV.
Okay. You'd show that to Mr. Healy.
And I called the B&V after I paid the reinstatement and make sure they got the payment. And they said they did, and they said my stuff was back to rights for driving was back to normal.
So, Your Honor, this is an order from the Portsmouth Municipal Court titled Release of Forfeiture. And it states that Registrar of Motor Vehicles to reissue the defendant's license to the original date of expiration to permit defendant to apply for a new license unless the defendant's license is suspended, canceled, or revoked on other grounds. So he appears to have gotten that straightened out, and he's also got a statement, confirmation of payment to the Bureau of Motor Vehicles. So I don't know what else he has to do to get the license reinstated.
Well, why don't we do this, because I think he had indicated that he thinks his license, do you think your license is reinstated now?
Care if I approach the bench? I got a severe hearing. I can't understand you.
Yeah, I don't have a problem with that.
Hearing aid in that ear and mention, I can't understand you very well.
Do you think your license is reinstated now?
Yes, after I made the payment, I called Columbus to make sure they got the payment and went through, and he also said that my rights were reinstated.
Okay. Mr. Heald, what's your thoughts if he's reinstated on this case?
As long as the court feels confident that it's been reinstated, we don't have a problem with dismissing the charge.
Can we get him right in? Okay. Tell you what, we're going to run to make sure that you're valid again.
Okay.
So if you would, just have a seat back in the back and we'll recall your case here shortly.
Okay, thank you.
Thank you.
State of Ohio versus Freddie Haywood, case number TRD 24-2267. Freddie J. Haywood.
This is State of Ohio versus Freddie Haywood, TRD 24-2267. Mr. Haywood was cited to be here today at 9 a.m. He has failed to appear. He'll be a habeas issue.
State of Ohio versus Brian Crawford, Case number CRB 24330. Brian Crawford.
This is State of Ohio versus Brian Crawford, CRB 24330. And Mr. Crawford, it looks like you might have been a little bit late today.
Yeah, I contacted Mr. Major, I said here last Friday. I can get,
That's okay. I'm just clarifying for the record.
Sorry.
Looks like we called this earlier, or no, sorry. You failed to appear. It looks like for a review hearing at some point.
last Friday, I contacted Mr. Major and spoke with him, and he said as long as I was here by this Friday, and I have a doctor's excuse. Apparently it's not in the car, but I can call or have it faxed if you want here in a minute. Like I can provide documentation.
So you're admitting that you failed to appear for the review?
I got in touch with Mr. Major, yes, sir.
I will recall any warrant that's out there, if there's a warrant out there, and that's a good report that you had. So that's going to kind of save you today. I'm going to set you back for another review, put you back on the review docket on December the 20th.
Okay, and on a quick question, Your Honor. I set up for community service. Can I do like half community service and pay the rest in, you know what I'm saying, the restitution in cash in the future, like when I get a
Well,
check?
restitution has to be paid, but if it's a fine, you can work the fine off on community service.
Okay.
As much of the fines court costs off as you wish.
But if I want to pay some cash for the fines, I can do that and community service?
Absolutely.
Okay, thank you. I'm saying, yeah, because I got applications in and everything. And
Okay. We'll see you back on December 20th at 9 a.m.
December 20th at 9 a.m. Thank you, Your Honor.
Thank you.
State of Ohio versus Nicholas R. Adams, case number TRD 201480.
It's the State of Ohio versus Nicholas R. Adams, TRD 201480. Looks like that it's alleged that Mr. Adams, you missed a review. It was a bench warrant issue. Looks like back on September 30th, 2024, for bond forfeiture. The admitted denied you failed to appear.
Oh, I admit it. Yes, sir. I was incarcerated in Grayson County, Kentucky since September the 7th up until last Friday.
Okay.
And I got in contact with the bail bondsman, and he told me to report today at 9 a.m.
Okay. I'll recall the warrant. It looks like you're down to 2 days of community service and your case is complete.
Yes, sir.
So if you can, I'm going to set you back December 20th.
Yes, sir.
If you have that completed and it's verified that probation has that and verifies it with you, you won't have to appear.
Yes, sir.
If there's a warrant that is still outstanding, I'll go ahead and call it.
Thank you, sir.
So we'll see you back then at 9 a.m. unless your case has been verified and completed.
Yes, sir. Thank you.
Thank you.
State of Ohio recalls John Waller, case number TRD 242273.
Okay. This is State of Ohio versus John Waller, TRD 242273. His license is valid at this time, so upon the state's request, this matter will be dismissed. Thank you.
State of Ohio versus Richard Watson, case number CRB 12760.
So the State of Ohio versus Richard Watson, CRB 12760. Looks like, Mr. Watson, it's alleged that you failed to appear for a review hearing on April 23rd of 2018. You admit or deny that you failed to appear?
I admit that I didn't know that I had a court date. I thought it was resolved. I paid a lawyer I hadn't had a ride over here or anything, and I thought it was done and over with, so.
Well, you've got all your community service done in this case, but you still owe a balance of $440.
Yeah.
This is a pretty old case that's out here. Do you have any payments you can make towards that?
Today, I don't have any money at all.
Are you working currently? All right, well, I'm going to go ahead then and order. We're going to be back on December the 20th for review, and I'm going to order that you have at least 2 days of community service completed. Now, by doing the community service, it's going to come off of your fines, so that's going to count off your fines. So, as long as there's no restitution, if you wish, you can work it all off. But you need to get this case closed out. It's essentially it's 12 years old. It's over. So we'll set you back for review at 9 a.m. I'm going to order that you have a minimum 2 days of community service completed by then, or that you've made some payment.
I didn't know that I had a fine. I'd paid a lawyer $500 to represent me, and basically that money just went down the drain. I could have paid the fine off.
And I can't speak to that as far as that goes. It just shows that we've got a balance of $440 owed.
All right, you said December
20th.
December 20th, and community, where do I do the community service? Can I do that in Kentucky?
You'll need to speak with Mr. Cooper here or Mr. Major, and they'll be able to set you up about that.
Because right now I have a problem with transportation, and I was wondering if I'd be able to.
They'll typically work with you on those things.
All right. All right, thank you, sir.
I'll be right now. Ma'am, it's on Zoom. Can you hear me? Ma'am, can you hear me? Ma'am, you're on Zoom and you have a Kentucky hoodie on. Can you hear me? Yeah. You need to mute your microphone. Every time you speak, you're speaking to the entire courtroom. When we get to your case, I'll call you when we get to your case. Thank you for muting.
State of Ohio versus Jessica Baisden, case number CRB 24715. Jessica Baisden.
The State of Ohio versus Jessica Baisden, CRB 24715. Ms. Baisden, I believe you just handed a copy of charges. Ms. Baisden, it's alleged that on or about November the 6th, 2024, you did knowingly cause or attempt to cause physical harm to John Paul Baisden, a family or household member, the violation of Ohio Revised Code 2919.25A of the Ohio Revised Code domestic violence for misdemeanor in the first degree. Maximum penalty 6 months in jail, $1,000 fine. How do you wish to plead?
Not guilty.
Okay, I'll accept your not guilty plea. Do you wish to be considered for counsel, for an attorney?
I may seek that out.
Okay, are you going to hire your own, or do you wish to be considered for court-appointed attorneys?
I'll do my own.
Okay, I'll note that you're going to hire your own attorney. How long do you think you'll need to accomplish that?
Maybe a month at least, or a few weeks.
That'll be fine. I will continue the bond. There was a bond posted by Mr. Sowards in this matter. And we'll set a pretrial for December the 9th at 10 a.m. If you hire an attorney and they need to move that, they'll be able to contact the court, but it's important you keep in contact with your attorney. If you haven't hired an attorney by then, you'll still need to appear that day on December the 9th. And it'll be at 10 a.m.
10 a.m. Thank you.
Your Honor, we need to discuss if there needs to be a protection order. We'll ask for protection order.
Okay. Ms. Baisman, the state is going to ask for protection order in this matter for now. Do you have somewhere to go other than anywhere around Mr. Baisman?
Yeah, we reside at different residences. He left our home on September the 19th.
That's fine. It's going to be a no contact order. You can't have any contact, whether it be in person, phone, text, social media, anything. You can't have any contact whatsoever with him until further order of the court.
Okay.
Okay? All right. They're going to give you the paperwork to sign, and we'll see you back at 7 o'clock.
State of Ohio versus Julia Hill, case number CRB 24522. Julia Hill.
This is State of Ohio versus Julia Hill, CRB 24522.
My hearing's not good today.
And this is looks like Mr. Morford was appointed her as her attorney, it looks like on October 25th. There was a failure to appear for a free trial, and we're going to have an arraignment on that failure to appear today.
And Your Honor, this is a special prosecutor.
Okay. Mr. Morford, does your client admit or deny that she failed to appear for the pre-trial?
Admit, Your Honor.
Does she have a good reason as to why she wasn't here?
Why?
The car got repoed,
Car was
taken.
repossessed, Your Honor.
Okay. She's presented herself here today on her own accord. I'll recall the warrant. And who is our special prosecutor? Mr. Ashworth is our special prosecutor.
It's just the trespassing fee.
Okay.
I didn't do it.
We'll go ahead, I'm gonna set this for December 2nd, because it appears Mr. Ashworth is already going to be here that day, and we'll let him know that he has this for another pre-trial at 10 a.m.
December 2nd, yes.
There you go. Not like yours.
Okay.
Thank you, Your Honor.
Thank you, Mr. Morford.
Thank you.
Make sure you show up.
Yes, sir.
You too.
State of Ohio versus Brittany Ennis, case number CRB 24697.
This is State of Ohio versus Brittany Ennis, CRB 24697. Okay. Ms. Ennis, have you received a copy of the charge?
Yes, assuming this is it right here.
I'm going to go through it with you. Ms. Ennis, it's alleged that on or about October 20th, 2024, you did knowingly cause or attempt to cause physical harm to Ashley Ennis, a family or household member. That will be a violation of Ohio Revised Code 2919.25A, domestic violence, the misdemeanor of the first degree. Maximum penalty is up to 180 days in jail and $1,000 fine. How do you wish to plead?
Not guilty.
Okay, I'll accept your not guilty plea. Do you wish to be considered for a court-appointed attorney?
No.
Okay, are you planning on representing yourself or hiring an attorney?
Hiring an attorney.
I'll note that you're going to hire.
Yes.
How long do you think you'll need to hire?
I'm sorry, I didn't hear you.
Any idea on how long you think it'll take you to hire an attorney?
Maybe like a couple days.
Easy enough. I'm gonna let you sign a $1,000 signature bond. That means you're signing that you're gonna show up to court. If you don't, as long as you don't show up, you don't have to post any bond or get a bondsman to do so. All right, I'm gonna set a pretrial for you for December 2nd at 10 a.m. If you hire an attorney and they need to move that date, they'll contact the court and let you know. If you haven't hired an attorney by then, or the attorney can be there that day, we'll see you back on December 2nd.
Okay.
Mr. Field, was there a request for protection order in this?
Yes, Your Honor. In fact, we needed to get the file out to get the particulars. So if we could have, is it Ennis?
Yes.
E-M-I-S?
E-N-N-I-S.
Oh, Ennis, okay. If we could have her stay around a little bit so we can get the protection order together, and
Okay.
we'll do it as quickly as we can.
Ms. Ennis, we'll have you sit back in the back for a second. You're not going to be able to have any contact with Ashley Ennis. Is there somewhere else that you can stay until?
This is so weird. I never had contact with her. I was just going to her house to pick up my son.
Well, and we're just here for an arraignment today, as far as this goes. So we're not really hearing evidence as far as that goes, but, so you were just going there somewhere, so you live somewhere else?
Yes.
Okay. Just until further order of the court, just don't have any contact, whether it be text, call, social media, anything, just no contact. Okay. They're going to, the state will bring the protection order over to you. Looks like I think they're walking over now. And once you've signed, and they'll get you a copy of it, you're free to go.
And when's the case set for, Your Honor?
December 2nd, 10 a.m.
State of Ohio versus Cameron Hass, case number CRB 24716.
All right, this is State of Ohio versus Cameron Hass, CRB 24716. Mr. Hass, you just handed a copy of the charge.
Yes, sir.
Okay. Mr. Hass, it's alleged that on or about November 5th, 2024, that you did knowingly cause or attempt to cause physical harm to Bria Eastman, family or household member, in violation of the Ohio Revised Code 2919.25A. It's a misdemeanor of the first degree, domestic violence, maximum penalty up to 6 months in jail, $1,000 fine. How do you wish to plead?
Not guilty.
I'll accept your not guilty plea. Do you wish to be considered for appointed counsel?
No, I'll get my own attorney.
Your own? Okay. How long do you think you'll need to do that?
As long as you could possibly get me.
I'm going to set you back December the 13th for a pretrial at 10 a.m. You posted a bond with Mr. Sowards. I'm going to continue that bond. And Mr. Hill does the request for protection order.
There is, Your Honor.
Mr. Hass, as part of your bond, there's a protection order that's going to be issued. You're not going to be able to have any contact with Ms. Eastham in this. Is there somewhere else you can stay during?
Yes, she don't live with me, but she has been trying to reach out to me. She has messaged me off my kids' iPad, and she's also had her brother try to contact me through my work.
Okay, well, I'll go ahead.
So make sure it works both ways.
It does not work both ways. You cannot answer her. So if she reaches out to you and you respond back, you're in violation. So until further order of the court, you can't have any contact with her, even if she insists upon it. Okay?
Yes, sir.
That's part of your bond. Protection order is going to issue. Once you've got a copy of it, you'll be free to go.
State of Ohio versus Kirkland Hampton, case number CRB 24717.
We'll see you back December 13th.
Thank you.
Thank you. This is State of Ohio versus Kirkland Hampton, CRB 24717. Mr. Hampton, did you receive a copy of the charge?
Yes.
Okay. All right. Mr. Hampton, it's alleged that on or about November 7th, 2024 in Fayette Township, that you did refuse to disclose name, address, date of birth when requested by a law enforcement officer who reasonably suspects that the person was or has committing or was about to commit a criminal offense. That's a violation of Ohio Revised Code Section 2921.29A1. Failure to disclose with order of police officer, it's a misdemeanor of the 4th degree. Misdemeanors of the 4th degree carry a maximum penalty of 30 days in jail and a $250 fine. How do you wish to plead?
Not guilty.
I accept your not guilty plea. Do you wish to be considered for court-appointed counsel?
Yes.
Okay. Are you working?
Yes.
Are you paid hourly?
Yes.
How much do you make per hour?
I just got a raise, so it's about $16.10, I think.
Okay. How many hours a week do you get?
It changes at Sam's Club. They switch around depending on the time of the year.
Okay. What would you say your average would be?
Right now, it's somewhere between 60 to 80.
Hours a week?
No, like every 2 weeks I'd be.
Okay. So we'll say 35. Do you have any dependents? Do you have any dependents?
I have one daughter.
Okay. You
Divorced.
qualify. I will appoint Attorney Roger Smith to represent you. I'm going to let you sign a $1,000 signature bond.
Your Honor, this is a 4th degree misdemeanor.
So 45 days is the time frame on that. Mr. Smith, when would you like to come back?
Let's see, let me take a look here. Sign that. Judge, I could do the 22nd of this month.
Let me take a look at it.
If that'll work, I've got other options if not. Or I could do the 6th of December. Or the 2nd, or 6th of December.
We can do the 22nd.
Okay, wait, so, yeah, November.
All right, I'll set it back for pre-trial of November 22nd at 10 a.m.
Thank you, Judge.
Thank you, Mr. Smith.
State of Ohio versus Terry J. Aldridge, case number CRD 24-718, A and B.
This is State of Ohio versus Terry J. Aldridge, CRB 24-718.
Yes.
A and B.
Thank you.
Mr. Aldridge, I believe you're just handing a copy of the charges. All right. In the A case, it's alleged that on or about August 29th, 2024, you did with purpose to deprive Speedway, the owner of property or services, knowing to maintain or exert control over said property or services, to wit, miscellaneous merchandise without the consent or owner of the owner or person authorized to give consent. That violation is a violation of Ohio Revised Code 2913-02A1, theft, that's a misdemeanor in the first degree, maximum penalty 6 months in jail, $1,000 fine. In the
Your Honor, may I speak, please?
Not until we finish
Okay.
the arraignment portion. And then the B case, it's alleged that on or about August 29th, 2024, you did with purpose to deprive Kroger, owner of property or services, knowingly obtain or exert control over said property or services, to wit, miscellaneous merchandise, violation of Ohio Revised Code 2913-02A1, theft, a misdemeanor in the first degree, maximum penalty 6 months in jail, $1,000 fine. Mr. Aldridge, how do you wish to plead?
Not guilty, Your Honor.
I will accept your not guilty plea.
May I speak now, please?
Give me one moment.
Okay, I'm sorry. I have something very important to say.
And I would caution you, I will accept your not guilty plea. I would caution you that we are recording here.
Yes, yes.
Anything that you say that would be against your interest, Mr. Hill with the state could use against you. So if you
Correct.
still wish to speak after that, I will
Yes.
certainly allow that. But probably before we do that, I'll ask if you wish to be considered for court-appointed counsel.
Okay, yes, and may I speak now? Okay, the thing is, this charge, and I have another charge with Staunton, or Stratton. No, no, I was wondering if we could put it all together, because this is all from the same thing.
Your Honor. I will appoint Mr. Stratton to represent you.
Yeah, because he's
Your
already
Honor,
representing me.
We're scheduled for the 15th. He's going to OVP.
Yes.
And so.
I'd like to compile all these together that way.
Yeah, I don't even know what
So,
but we'll do it,
You're
yeah.
set for next Friday?
If that's the 15th, Your Honor.
Okay, yeah.
I just has to be allowed to sign his own bond on this, and then we'll set it on the 15th and deal with it all together, Your Honor.
Okay. I'll allow him to sign a $1,000 signature bond. I'll set it for November 15th with his other cases at 10 a.m.
And thank you, Your Honor.
Hold on.
Yeah.
Thank you, Your Honor.
Thank you, Mr. Stratton.
Thank you.
State of Ohio versus Shaylin Roman, case number TRC 221521, A, B, and C. State of Ohio versus Shaylin A. Roman.
This is State of Ohio versus Shaylin A. Roman, TRC 221524, A, B, and C. Mr. Roman, it appears that there was a bench warrant for failure to appear that was issued on June 21st of 2022. It looks like you appeared on your own accord here today. You admit or deny that you failed to appear?
Well, it was
troublesome to get down here. I take care of my grandparents at home, and I don't have a license, and I couldn't come down here. So sure, yes, but I did not appear.
Where do you live?
Cleveland, Ohio.
Okay, I'll recall the warrant that was issued. It looks like there was an attorney appointed to represent you, Lance Thompson.
Yeah, there was a public defender appointed to me, but I would, if possible, could I change my plea?
That would, well, with an attorney appointed to you, here's what I'll do. How about this?
Sure.
I don't want to take a plea without you speaking with an attorney, because you have an attorney here.
Okay.
So what I will do is I will appoint Attorney Luke Steyer to represent you.
Okay.
And if, after speaking with Mr. Steyer,
Sure.
that's what you wish to do, then he can ask for it to be recalled. I will keep the same bond that's currently in place. And I'm going to go ahead and set a new date for you, but in the event that that's what you wish to do, you can ask for it to be recalled.
So I'll have to reappear then?
I'm going to go ahead and set it in case after speaking with Mr. Steyer, you change.
Sorry, I was...
No, that's okay. I just want to make sure you understand what's going on.
Okay.
And then, if you change your mind, then we'll have a new date, and we can maybe even set you up to appear via Zoom, since you're from Cleveland.
Well, don't say anything, we're in court.
Okay.
So tell you what, he's just gonna give us a new date, and if we decide we need the new date, you could even appear by video. But I'll go out and talk to you, we may decide we don't need a new date.
Yeah, okay. If you don't need the new date, you can hit Mr. Steyer, I'll ask it to be recalled, and we'll take care of it today.
Sure, thank you.
Okay, and what's the date gonna be, Your Honor?
Mr. Steyer, I'll kind of give you some leeway when you're here. I know you're here most Mondays and Fridays.
Let's go to December 13 for the time being, Your Honor.
Okay.
Let's write that down.
And if
We'll talk about it out there.
Okay.
December 13th at 10 o'clock.
December 13th?
Mm-hmm.
December 13th, pre-trial, 10 o'clock. In the event that we need to recall Mr. Steyer.
Yeah. Thank you.
Thank you.
All right, you just step out here with that, I'll talk to you.
Sure.
We're ready for a pre-trial, Charlotte.
Okay. If you got a pre-trial, need you in the courtroom.
See, pre-trial in the courtroom now, pre-trial in the courtroom now.
State of Ohio versus Mark Blackburn, case number CRB 24-364.
This is State of Ohio versus Mark Blackburn, CRB 24-364. Mr. Blackburn is present, his attorney, Mr. Roger Smith. State's represented by attorney Philip Heagle. Set for pre-trial.
Yeah, it should. I got that, yeah. Judge, he contacted my office yesterday. I wasn't there. He needs a couple more weeks to get paid to get this taken care of. It's a dismissal pump.
Third Wednesday.
Third Wednesday,
I'd pay it off.
so whatever that would be. Could we go to December 2nd just to be sure?
That'd be fine.
That'd give him about 3 more
Yeah,
weeks.
that's good.
I'll reset this matter at defendant's request for pre-trial at 10 a.m. on December 2nd.
And Judge, if he pays the cost, am I correct that we're finished before then, or is it one he has to appear?
We'll make it so, is that the agreement, Mr. Heald?
We're not opposed to that, Your Honor.
Okay.
Oh, he was, let's see, did we already do that? One of the other agreements on this was that he was going to forfeit the gun.
That's fine.
So we need to do that.
We already agreed to do that. We've done an order. We don't object to forfeiting the gun. That was the basis for the
Yeah,
dismissal.
if you wish to submit the order, is that correct, Mr. Blackburn? That's your agreement?
It's forfeited gun to get the case dismissed, yes.
Okay.
That was the agreement, Judge. I didn't know we had reduced it to writing, but apparently we had it.
Well, I honestly don't know if we have or not.
Okay.
But if Mr. Hillboy, if we have and he presents one, I'll sign off on it. That way he can come in at any time, pay the costs, be done. It's in, who's got it? Which agency? Who arrested you? What agency? Which law enforcement agency? South County, Highway Patrol, Sheriff?
I guess.
I think it was the sheriff, probably the sheriff.
It's the sheriff.
If you
I will, I made a note to file it if the officer paid it here, and there'll be an entry tender for forfeiture of fire.
Hey, Judge.
Roger, I'm going to be pretty busy here.
State of Ohio versus Teresa Patton, case number CRB 18485. Teresa or Teresa Patton, case number CRB 18485.
So the State of Ohio versus Teresa G. Patton, CRB 18485. Ms. Patton has not appeared. It's now 11:01 a.m. Her attorney, Mr. Smith, is here on her behalf, and the state's represented by Attorney Philip Keel.
Judge, she has contacted my office. I have no explanation why she is not present today. This is a case that originated 6 years ago. I would ask if there have been sworn issues that Your Honor hold for 7 days and let me make attempts, because she has called the office. Maybe I can find her.
Okay, Mr. Hill, thoughts?
We're not opposed.
All right, there'll be a bench warrant to issue in 7 days for failure to appear.
State of Ohio versus Kathy Haycook, case number CRB 24694. Kathy Haycook.
There's a cross-filing judge with Mark Blacksberry,
She's on the screen.
which is Tyler's case.
Who's the cross-filing?
Mark Blacksberry, I think is his name.
Marksberry.
I think
Tyler.
that's Mr. Tyler's.
It is.
Okay, first case is State of Ohio versus Kathy Haycook, CRB 24694. Ms. Haycook is present via Zoom. Her attorney is Mr. Roger Smith, who is here.
State of Ohio versus Brian Marksberry, case number CRB 24590, CRB 24695, CRA 24362.
And the companion case is cross-filing on the CRB 24590, the State of Ohio versus Brian Marksberry. There are additional charges of CRB 24695 and CRA 24362. Mr. Marksberry is present with his attorney, Mr. Tyler Smith. The state is still represented, or still being represented by Attorney Phil.
May I address my client briefly, Your Honor?
You may.
Ms. Haycook, can you hear me? Okay. There's been an offer tendered by the state that we would go out 90 days, no further problems. Both cases would be dismissed upon payment of cost. Is that something you'd be interested in, or do you want me to request a trial date?
That's fine.
Have them both dismissed? Okay. I think that's where we're headed, Judge, depending on what my brother's client has.
Well, there's another complicating factor, and that is that there's 2 charges that occurred before this cross-filing that are still pending, and I don't know what, it gets complicated for the prosecutor's office to be pursuing all these charges because of the potential for a conflict.
Yeah, I was just speaking to the actual crossfire. I'm not counsel on the other 2 cases. Well, I wouldn't be because she's an alleged victim, so.
Sure.
I'm just speaking to the one that is an actual cross-filing.
All right, as far as the cross filings go, Mr. Highway Smith.
Yes.
What are your thoughts?
Well, Ms. Haycock's the alleged victim in 3 cases. I'm sure she's more than willing to do a 90-day continuance, so she's not proceeding. My client wouldn't object to that, but I think this needs to be, everything goes away, they both go away from each other. Otherwise, we're just going to have a trial, because he has that right to have a trial in the other 2 cases, and then on the cross-filing. So I don't know the state's position. Let me address my, Ms. Haycock, can you hear me? There seems to be a lag. Can you hear me?
We're breaking up a little bit, but I'm hearing that.
Okay, what is the way this case is played out or shaped up? He has 3 separate charges against him. Are you willing to dismiss everything and let it go at that, or are you seeking to prosecute on the other 2 cases that are not cross-filings?
I'm just done with things. It's taking so long with all this process.
Okay.
And I'm not even in town at the moment. I'm not coming back in town, but I'm just with my home.
Okay.
So, it's going to be wise for you to be coming in to this.
I wasn't able to understand.
I didn't understand, but
I'm not in contact with the
I'm still. Do you have any objection to just settle this today, to allow the state to dismiss all charges against Mr. Blacksberry?
Yeah, I just rather settle it, we done.
Okay.
I still didn't
throw it back to the state.
She'd rather settle to be done.
She wants to, all this.
And where are you today, Ms. Haycock? Where are you, Ms. Haycock? Maybe somebody else's voice can get through.
Ms. Haycock, Prosecuting Attorney Philip Hill had a question, and he wondered where you are today.
I'm in my own town, and I'll be back in a week. But I'm back in Municipal, Ohio.
So Mansfield, Ohio, should back in a week.
All right, well, we'll just move to dismiss all the charges.
I guess we need to date 90 days roughly out from today, Your Honor. And Your Honor, the only thing that I would ask is that Ms. Haycock has my client's car and keys. It's his car, and if she's in Mansfield, Ohio for another week, he's not going to have the access to his car. He actually has a job. Although you're an inpatient.
I'm an inpatient
He's an
treatment right
inpatient,
now.
so that's not going to matter about the car, but he does need to get his car back, so.
That's not really in...
I'm just saying that we can make an arrangement. Yeah, so I guess in a week, she'll be back and the car will be returned. Now, while he's an inpatient, he's not going anywhere anyway. We do need to get the car back.
Let's go out to February the 10th on both cases. Now, Mr. Marksberry, I do want to note here well, give me one moment before I agree to this. I want to take a look at this report.
Okay.
Mr. Marksberry, this isn't a very good report.
No, I made a mistake. I've had a lot of things go on, and I recognize it. I take accountability for it, and obviously there's some things I need to work on, and I thank Mr. Majors and Mr. Heald for giving me the opportunity to go to a treatment center and work on those things and I've been through treatment before, but I think I missed something, and that's, it's important to me. I'm an older man, you know, I'm not an old man, but I'm older, and running out of time to get things right, and I really want that opportunity to be able to get that figured out.
Mr. Hill, with Mr. Marksberry being in treatment, does that change any of the recommendations?
It does, Your Honor, and I hadn't really considered that before. And I also know that Mr. Marksberry is wearing a GPS monitor too, so we can't really go out. I wouldn't think we could go out 90 days. I'd rather come back sooner. I think that I would like to have another hearing when Ms. Haycock is back here, so we can get a more definitive understanding of how this is going to proceed. Because it's a little bit different than just a cross-filing. And we want Mr. Marksberry to continue with his treatment, and hopefully he'll be successful in that.
Okay.
So maybe if we could come back in 3 weeks or something.
I think that's a better idea at this point, because there's more moving parts than I was originally familiar with.
Judge, I have the November 22nd date or December 2nd. Due to trials, those are really my only two.
December 2nd work for you, Mr. Smith?
That's fine, Your Honor.
I'll set both of these cases back for pre-trial on December 2nd at 10 a.m. Okay. Ms. Haycock, can you hear me?
Yes.
Okay, what we're going to do is, because there's so many moving parts and because it's been kind of difficult for you to hear, we're going to set this for another pretrial on December the 2nd. You'll need to be here in person that day, and then there may be a resolution on it at that time, but I want to make sure that you're here and that everybody is on the same page and understands what's going on. So it'll be December 2nd at 10 a.m.
Thank you, Judge. Thank you.
Thank you.
Your Honor, I have something on Mr. Marksberry.
Okay.
He came in on an ankle monitor violation, and I placed him in custody. That time I asked him to do a urine screen, which he submitted to. He came back with positive for amphetamines and methamphetamines, and in order not to go to jail, he went into inpatient treatment in hometown. I just wanted to make you aware and give you a copy of the drug screen.
I believe the court's already aware of that.
Yeah, he's there, we're keeping him there, but
Yes.
thank you for drug screen at that point, because I did not have that problem.
I apologize, I didn't hear the case called, or I've been in earlier.
No worries, thank you.
Thank you, Your Honor.
State of Ohio versus Tanner and Pitt, case number CRB 24391.
The State of Ohio versus Tanner Click, CRB 24391. Mr. Click is present with his attorney Roger Smith. State is being represented by Attorney
Judge, this is a case that was set out to be dismissed by payment of cost. My client's indicated he's short of funds right now to pay the cost. Can we use that December 2nd date, Judge? He says he can't have it paid by then.
Okay. Be set for December 2nd, 10 a.m.
Sounds good. And again, I'm assuming if he pays the cost before that time, like the other case, the case will be terminated.
That'll be fine.
State of Ohio versus Constance Davis, case number TRC 241751, A, B, and C.
Oh, okay.
Constance
Thank you, Your
Davis.
Honor.
Thank you. This is State of Ohio versus Constance Davis, TRC 241751, A, B, and C. Constance Davis. Ms. Davis has been called for and has not appeared. Time's now 11:14 a.m. Our attorney, Mr. Roger Smith, is here on her behalf. State's represented by Attorney Phil Keel, and I was just handing the report from a treatment provider.
Judge, I have not seen her, but in fairness, I've not been in the lobby since 8:30, but she doesn't appear to be here. I think that we entered a plea, if I'm correct, Mr. Hill.
Yes, on
She
October
will do some
25th.
treatment, as a high test, possibly take into consideration if she completed treatment. Look at this report. It sounds like she's,
Did she leave?
She assessed in at residential level and has an adult autistic child, so we were trying to work with her on an outpatient basis, but under the understanding that any mess up would put her in residential. And yesterday, she called, said she was going to urgent care, wouldn't return her calls. I assumed that she was drinking, and we've just not been able to make contact with her.
Okay.
Judge, in that case, I would ask if we could come even just a week continuance, maybe I can get a hold of her, or they can get a hold of her.
I'm a little concerned on this one. I'm going to go ahead and issue the bench warrant.
We hold it for 7 days?
I will give
Okay.
you 7 days.
That's fair enough, yeah.
In case, if it wasn't for the urgent care portion, then I will issue it immediately. But given that, I will do the bench warrant in 7 days. But she's certainly going to have to explain it.
I want to reach out to her, Judge. Yeah, I'm shocked she's not here. I really thought she'd be here.
Thank you, Your Honor.
Thanks.
State of Ohio versus Cody J.W. Mead, case number TRC 23-152, A, B, and C, PRC 22-1690, A and B, PRD 22-2101, A and B.
All right, this is State of Ohio versus Cody J.W. PLC 23-152, A, B, and C, PRC 22-90, here 22-2101. Mr. Mead is present, attorney Mr. Robert Smith, state recommended by Attorney Phil.
Judge, he's at OVP. We were hoping Bree would be here to report. She might be here talking to another patient out in the hallway, but we've been here a while. I'm hoping it's a good report. We can conclude this today. As Mr. Hill knows, we've been with Cody for an extended period of time, but I guess it will depend on what Bree tells us. He's indicated it should be a good report. That's right.
It is a good report. All right, well, Mr. Mead, you still owe on the TRC 23 case a total of finding cost of $990. You've got a balance of $1,110 on the 22 case, and on the TRC 22, and on the other you've got $320. I'm not particularly worried about that at this point. I'm worried more about your recovery, and you're doing well in that. But what I am going to do is, because you're doing so well, I'm going to move you back to the review docket at this point, so that you're not showing up late for pre-trials and the like. You're still going to be under the obligations to complete your treatment, and then you'll still have fines and court costs that you're going to owe that you'll have to work through. But I'm going to put you back on review, and I'm going to, because you've done so well, I'm going to go out a little bit further.
I broke my fibula and tibula about 3 months ago. I'm back to work as of last week. So them fines will be taken care of. I got 20 a day to put on it. I do roofing for an occupation, so this I get 200 a day. Sounds like a lot, but with this winter around the corner, getting 4 days a week is really, really hard. But I got money today to pay on it, and that's the next step to work on.
Okay. That is all good news, good report. Good news you're back to working. I do understand the winter months are a little slow. As long as you're making an effort, we'll work with you on that. I'm going to set this for a review hearing at 9 a.m. on January 17th. And you know, the quicker you work through it and get it taken care of, then you'll be out from under you get your treatment done, get everything paid off, and cases will all be closed.
Okay, altogether, that was close to 3,000?
It would have been, about 2880.
Okay. All righty, thank you.
Thank you, Your Honor.
Thank you, Judge.
State of Ohio versus Paul Snavely, case number CRB 24318.
So the State of Ohio versus Paul Snavely, CRB 24318. Mr. Snavely is present, and his attorney, Mr. Roger Smith, state's represented by attorney Philip Heald. Well, that's an excellent report.
I thought so.
Looks like you've got a graduation date set for January 1st. So,
Turn over a new leaf here. Seems appropriate.
gentlemen, what are your thoughts?
I don't want to come back one more time before then or come back closer. I'll leave it to the prosecutor's discretion.
We want to get him across the finish line. He's done good so far, so we want to get him there.
All right, why don't we do this? Come back January 3rd. For a pretrial at 10 a.m.
It's fine.
And at that point, you should be graduated, and hopefully we can get your case fully resolved.
Thank you, Your Honor.
Thank you, Your
See you
Honor.
next year. Yep.
State of Ohio versus Jacob Spears, case number TRC 241511 A and B.
So State of Ohio versus Jacob Spears, TRC 241511 A and B. Mr. Spears is present with his attorney, Mr. Roger Smith, and the state is represented by attorney Philip Heald. And I have a note here that Mr. Spears has been being seen by Family Medical.
I'd like to know where he's in treatment.
Family Medical Center. Family Medical Center.
Let's approach it, tell the judge what we want to do. Well,
They have not said anything. Yeah, I can agree with that. Mr. Smith, when would you like to come back?
Judge, I'm here the 2nd or 6th of December.
Let's do the 6th, the 2nd, so I can get a little more crowded.
Okay.
So we'll come back on 12/6 for pretrial at 10 a.m. Mr. Spears, it is incumbent upon you, I know Mr. Smith says that you believe you signed the release. If you haven't, you need to get that signed. And on top of that, if they haven't sent one, I will probably need you to show up with a report from family members and then be able to provide the report.
All right.
All right, so see you back December 6th.
All right.
Make sure you get their report.
State of Ohio recall Shayla Roman, case number TRC 221524, A, B, and C.
This is State of Ohio versus Shaylin A. Roman, PRC 221524, A, B, and C. Mr. Roman is present, with attorney Luke Steyer.
Your Honor, I just want to explain a couple things for the record based on the unusual circumstances here. Mr. Roman is a resident of the Cleveland area, and so it is a pretty big endeavor for him to get down here. I took a look at the charge. I explained to him the seriousness of an OVI charge, the fact that it is going to stay on his record permanently, and that future charges would be enhanced penalties. He recognizes that, and I think has made an informed and intelligent decision to enter a plea of no contest with stipulation of facts sufficient to support a finding of guilty in this matter. So having fully advised him, I'm going to make that plea on his behalf.
Okay. Is that correct, Mr. Roman?
That is indeed correct.
Okay. And you understand that you may have, and I don't know what's gone on in this case or what it looks like, but you may have defenses to this that you would be waiving if you intend to enter the guilty plea.
And if I may, Your Honor, I've explained that to him, and explained that I can't even tell him what those defenses are without going further in the process, getting discovery, watching the video, things that I simply can't do today.
Sure, absolutely. But knowing that, Mr. Roman, you still wish to enter a guilty plea?
Yes, sir.
Okay. I will accept your guilty plea then, and that is that to all charges pending?
Yes, Your Honor.
All right. I'll accept your guilty plea. And Mr. Heald, Mr. Steyer, is there a sentencing recommendation?
We hadn't discussed that. I guess it is a first offense. It is a refusal. I explained to Mr. Roman that the court's standard on a refusal without further information is usually a fine on the higher end of the scale, although the specifics of that are up to the court. My expectation, I hadn't discussed it with Mr. Heald, but I expect he would agree that 20 days in jail suspended with a requirement that Mr. Roman attend the 3-day school, 30 hours community service, a fine at your discretion, and a 6-month license suspension is what would be likely. The other charges, the court usually just sort of decides how to handle those. There's a driving under suspension and a speed offense.
Okay. Mr. Gill?
We don't take any position other than that the mandatory minimums.
Okay. On the OVI case, it'll be 20 days jail, suspended to the 3-day VIP school. It'll be a $750 fine. I'll order him to pay the court costs. Be 30 hours community service. There will be, since it's a refusal, there'll be a 1-year license suspension, but I'm going to date it back to the date of the offense. So your suspension should at this point already be up. So it'll be, the suspension will go on, but then you should be already be up to get reinstated.
If I may, Your Honor, what that's going to mean, sir, is you're going to need to go to the BMV and pay the reinstatement fee before you're legal to work. There was another suspension on this ticket, so you're also going to pay that reinstatement fee. So I'm obviously going to tell you, you can't drive until that's taken care of.
Okay. Thank you.
No problem. It'll be 2 years level 4 probation. On the speed offense, it would be a $39 fine. And on the driving under suspension, I'll do a $50 fine.
Okay, and if I may ask, are there like documents that I could look up, like online or anything like that?
You'll get an
like the
entry.
fines?
Yeah.
You'll get a judgment entry.
Okay.
When you finish in here, which we're not done quite yet, you step out and wait, talk to this guy here with the tie that was at the door, and he's gonna talk to you. It's gonna be a little bit of time probably because he's working the door as well, so you may have to sit around for a little while.
Sure.
And it's only going to be one court cost on this.
Is there a review hearing date, Your Honor?
There will be. Make
May
sure-
the 9th,
Okay.
25. And that will be on the entry as well.
As long as you have everything done by that day, and you need to check with the probation officer to make sure of that, you don't have to come back that day. If not, you're going to have to be here in person on May 29th at 9 a.m.
Okay.
Get everything. I went through the swap kind of after that. All right, you'll need to see probation on the left side of the building before you go, and they'll give you copies of the entries, get you signed up, and go from there.
Okay.
You'll see back May the 9th for review, unless you have everything completed.
Okay, thank you.
Thank you.
Thank you.
State of Ohio versus Cody Davidson, case number TRD 242195.
The State of Ohio versus Cody Davidson, TRD 242195. Mr. Davidson present, and with his attorney, Mr. Steyer, state represented by attorney Philip Heath. And I believe this matter was set for a trial, but my understanding is there's been resolution.
It was, Your Honor. Mr. Heald made an offer that in exchange for a plea of no contest with stipulation of facts sufficient to support a finding of guilty, he would recommend, and we would join a recommendation of a $50 fine and court costs.
Mr. Hill, is that correct?
That is correct, Your Honor.
All right. And Mr. Davidson, is that what you wish to do, is enter a no contest plea and stipulate to the guilty finding?
Yes, Your Honor.
All right. I'll accept your no contest plea and I'll enter a guilty finding. It'll be a $50 fine and court costs. If you can pay that today, there will be no probation.
Thank you, Your Honor.
Could you pay that today?
Yes.
Okay, get cash because they don't take a card at the window. Okay, cool. All right, you can take care of that then, Your Honor.
All right, so if, in the event that, and I'll go ahead and caution you, because we had this happen recently, in the event that you don't pay that today, and or if you leave and need to go get money, don't come back, you may end up with a warrant over it. So the case won't be fully closed out until that's paid. So I'll go ahead and set I'm going to go ahead and set the review date so that's May 9th, for May the 9th. However, my understanding is you're going to pay that today, and so once you've paid that, that review date will then be disposed of. Okay, so we close.
All right.
Thank you, Mr. Stiers.
So if you don't get it paid, you gotta come back that day. It's gonna be $175.
State of Ohio versus Ethan R. Anderson at the Lawrence County Jail, case number CRA 24706, and Nicholas Meyer on deck.
All right, this is State of Ohio versus Ethan R. Anderson, CRA 24706. Mr. Anderson is present via Zoom at the Lawrence County Jail. Mr. Anderson, can you hear me?
Yes, sir.
All right. His attorney, Tyler Smith, is present, and state's represented by Attorney Phil Keel. Mr. Smith.
Yeah, Your Honor, Mr. Anderson, we were here last week on the arraignment. A bond was set at $10,000 OR with a GPS inpatient treatment Bethesda. Obviously, Taylor's here from Bethesda. We need to get him in the treatment. He's been sitting for a week waiting on a GPS monitor. I've talked with Mr. Hill. It's our opinion that he needs to get into that treatment. I don't know if it's something that we can forgive the GPS monitor or however Mr. Hill would like to do it so he can get into treatment. And if one comes available, it can be put on, but I don't know. I think sitting in jail is not helping anyone. I don't know when a GPS monitor becomes available.
Sure. We have Mr. Major step in the courtroom.
Yes, Your Honor.
Any idea when a monitor may be available?
Whenever we take one off, we don't have any available, we got 10 out right now. So we'd have to take one off before we have one available.
Are there any that you know of that would be close to being time to take off at this point?
Not that I'm aware of right now, Your Honor. I've not been approached by anybody to have one taken off.
Okay. Well, here's what I'll do. I'm familiar with Mr. Anderson, and I believe Mr. Anderson does have a drug problem, and I'd like to see him get help. Mr. Anderson, before we even go any farther as to this, do you want help?
Absolutely, sir. I've done this long enough. My life, I've done this. I'm 28 years old, and I've been in and out of jail. I'm to the point now, I want help. I want to get my medicine straight. I want to get my head straight. And I want to be somebody. This is really getting old.
And I'm familiar with Mr. Anderson. I had represented Mr. Anderson, I believe, when he was 18 years old.
Is that correct?
Yes.
I thought that was you, sir.
And so I would like to see him get help and do well. Now, Mr. Anderson, what I'm considering doing is I'm considering allowing you to just OR into treatment without the monitor until one's available. But
I would not make a mistake. I would absolutely, I would honor that.
I'm going to give you, I'm leaning towards giving you a shot at it, but if you end up, if you go to treatment and you take off and you don't stay, you don't finish treatment, then whenever you do come back before the court, it's going to be a lot more stringent upon you. Do you understand that? You're probably not getting out of jail at that point.
Yes, sir. I understand completely.
Okay. I will allow him to sign a $2,500 signature bond, and I'm going to remove the GPS requirement on his bond, assuming that the state would be okay with that as well.
We are okay with that, Your Honor. As a matter of fact, I would also like to make a motion here with respect to 24 CRA 706. In reviewing the facts of the case, I don't believe that we can prove that there was a deadly weapon involved. So I think appropriately it should be charged as a first-degree misdemeanor under 2921.33B. There was an officer that received a slight injury during the resisting. So that's the appropriate charge, so we don't have a felony anymore.
Okay.
No objection to the amendment.
No objection.
Yes.
All right. Mr. Anderson, I'm going to order that you can only be picked up by your treatment provider in this, and we're going to set you a new pretrial. I don't want to go too far out because I want to make sure that you get into treatment and that you're doing what you're supposed to do. So I'm going to set this out for till November the 15th, even though we're a little crowded.
And that'll be on the pretrial docket?
That'll be on the pretrial docket at that time. So Mr. Anderson, I'm going to give you a shot. You got to be back here in 1 week. That'll get you into treatment, get you started, and the treatment provider will be able to bring you up, make sure that you're doing what you're supposed to do.
Yes, sir.
So we'll see you back in a week.
Yes, sir. So does that mean that they're coming like today or?
We're coming today.
They're coming to pick up.
They're coming today, so we've got to get the.
Thank you, guys.
No problem. We've got to get the bond forms taken care of,
Thank you
and
for
then they'll be able to come take care of you.
Thank you guys so much. I promise, I intend to work for your tax district. So thank you guys.
You're very welcome.
See you next Friday, Mr. Anderson.
Thank you, Your Honor.
Yes, sir. Thank you guys.
Thanks.
State of Ohio versus Nicholas Bayard, case number CRA 24721. Jonathan Cole is on that.
All right, sir, are you Nicholas Bayard?
Yes, Your Honor.
Okay, can you hear me? Okay.
Yes, Your Honor, I can.
All right, have you been given a copy of the charge?
Not yet, but I'm already aware what they are, the multiplication and the reference.
Well, we're going to go through what you've been charged with here, and I'm going to arraign you. Once I go through the charge with you, I'm going to have some questions, but I want to go through some of your rights. You have the right to remain silent, so anything you say is being recorded right now could be used against you by the state. So if you have an explanation you want to tell me, you may not want to do that without speaking to an attorney. You have a right to have bail. You have the right to make the state prove the charge. Ultimately, each element of the charge beyond a reasonable doubt. So, Mr. Bayard, it's alleged that on or about November the 7th, 2024, without the express or implied consent of the other person, did use, obtain, or possess any personal identifying information of another person with the intent to represent the other person's personal identifying information as the person's own personal identifying information? It's a violation of Ohio Revised Code 2913.49B2, identity fraud, felony of the 5th degree. Felonies of the 5th degree carry a maximum penalty of up to 12 months in prison and a $2,500 fine and up to 500 hours of community service. Do you wish to be considered for an appointed attorney?
Yes, and can I also ask for clarification, because I was told that I had a falsification charge, and I didn't have any documents with anybody else.
Well,
Any documents?
there should be something sent to the jail, but the state has charged you with identity fraud, a felony in the 5th degree. I don't have any further information other than that, nor do I have any further charges. So,
Is that my only charge now?
that is the only charge that is currently filed.
Okay, but I guess there was a misunderstanding when I brought it, and that's, okay, I'll just wait till we get the charges on that, but we can continue. Sorry,
Okay.
I had a misunderstanding.
No worries. Sometimes charges change from the time you come in till they're filed. Sometimes they go up, sometimes they can go down. It just depends. It sounds like yours went up from that level. Are you currently working?
Yes, actually, I just had a second job as well. My first job was at UJ in Huntington.
Okay. And are you paid hourly there?
Yes, but over $1.75, I mostly do tips.
Okay. And your second job?
I just had a second job down at the hospital in Ashland, where my girlfriend works in the kitchen.
Okay. Are you paid hourly there?
Yeah, but I haven't started yet.
Okay. I'm going to find that you qualify. I'm going to appoint Attorney Sean Stratton to represent you. Before we do bond, I would like to have him urine screen at the jail and see what comes back before we do you have a hearing on your bond. So, Mr. Bayard, I'm going to order you to be tested, and then
So what's going on?
I'm going to have you urine screened to see if there's anything currently in your system, and then we're going to have you come back up and have a hearing on your bond.
Okay.
Mr. Stratton, it'll be today.
Okay.
And Mr. Stratton is going to be appointed to represent you. He may wish to called down to the jail to speak with you as well.
Okay, well, can I just say right now that I can test positive for THC and only THC because I don't do anything else?
Well, we're still gonna have you tested, and we may even have you assessed.
Yeah, that's fine. I'm totally willing to do all that. I just, the bond meeting is gonna happen today, right?
It will happen later in the docket. We'll have you recalled and have you come up.
Yes.
Okay, thank you. I was just making sure because my family was concerned.
Thank you. Mr. Stratton, can you approach?
Yes.
We're going to be heading on to the next case, and we'll recall you here in a few minutes.
State of Ohio versus Jonathan Cole, case number CRA 24600, and Anthony Giamarco is on deck.
All right, this is State of Ohio versus Jonathan Cole, case number CRA 24600. I've got, sir, Mr. Cole. All right, I got Mr. Cole present via Zoom. His attorney, Tyler Smith, is present in the courtroom. State's represented by Attorney Philip Heald. And it appears that on October 31st, Mr. Cole was discharged from services at RRS.
Carmen, can we approach real quick?
You may. I don't know exactly what.
we recall this?
Mr. Cole, your case is going to be called a little later in the docket. Prosecutor's office and your attorney need further time to speak on this matter. So we'll call you back out here shortly, okay? All right, thank you.
State of Ohio versus Anthony P. Gianmarco, case number CRB 24724, and Justin Hargis is on deck.
This is State of Ohio versus Anthony P. Gianmarco, case number CRB 24724. Sir, are you Anthony P. Gianmarco?
Yes, sir.
Okay, have you received a copy of your charge?
Yes.
All right. I'm going to go through the charge with you. We're going to do an arraignment. And then I'll be asking you for a plea. You can either enter a guilty plea, not guilty plea, or a no contest plea. Guilty plea means you're admitting the violation. A not guilty plea means you're denying the violation. And a no contest plea means you're not admitting the violation, but you're not contesting the facts surrounding the violation, and that you agree that I can find you guilty if I think the state would have enough evidence. You have certain rights before the court. You have the right to remain silent. We are recording, so if you try to give me an explanation and it's not in your best interest, the state can then use that against you. You have the right to have reasonable bail set. And you also have the right to force the state to charge, have a trial, and force the state to charge to prove each and every element of the offense beyond a reasonable doubt. You understand those rights. You also have the right to an attorney, and if you can't afford one, we can appoint one for you. So, Mr. Gianmarco, it's alleged that on or about November 7th in Fayette Township, that you did with purpose to deprive Walmart, the owner of property or services, knowing to obtain or exert control over said property or services, to wit, miscellaneous merchandise, without the consent of the owner or a person authorized to give consent. That's a violation of Ohio Revised Code 2913.02A1, theft and misdemeanor of the first degree. Maximum penalty is 6 months in jail, $1,000 fine. How do you wish to plead?
Well, Your Honor, I did, man, so I'm guilty.
Okay, I will accept your guilty plea, but prior to having a sentencing, I want to have you drug screened down at the jail.
All right, been drug screened today.
Well, if that's the case, then they can send us up a copy of it, because I don't think that we have a copy of it yet. So I either want you screened, or if you were screened today, I want to see the results of that screen before we do sentencing. So we'll have to recall you back out here, and once that's accomplished. Yeah, I'd like to have you rescreen. I've dealt with APA, and you can't, unless you walk into their office, you're never going to even get them on the phone. So we'll have him rescreen, and then we'll call you back out for sentencing.
Your Honor, there's something I need to say about.
No, I'm not interested. I'm not interested in hearing that right now. I'm going to have you screened, and then we can talk about what's going on from there.
All
right, so we'll recall your case.
State of Ohio versus Justin Hargis, case numbers CRA 24722 A, B, and C, and CRB 24724. And Jeffrey Holly is on deck.
All right, this is State of Ohio versus Justin Hargis, CRA 24722 A, B, and C. Mr. Hargis, can you hear me okay?
Yes, sir.
All right, have you received a copy of your charges?
Yes, sir.
All right. Mr. Hargis, we're going to go through them. Start with the first charge, the A case, CRA 24722. Mr. Hargis, it's alleged that on or about November the 6th in Fayette Township, that you did knowingly obtain, possess, or use methamphetamine, a Schedule II controlled substance. Amount of said drug equals or exceeds 5 times the bulk amount, but less than 50 times the bulk amount, to wit, 18 grams, violation of 292511 AC1C, aggravated possession of drugs, a felony of the second degree. Maximum penalty on the felony of the second degree is 8 to 12 years in prison and up to a $15,000 fine. The second charge under the B case is that on or about November 6th in Fayette Township, you did with purpose to deprive Walmart owner of property or services, to wit, miscellaneous items valued at $1,472.01, knowingly obtain or exert control over said property or services by deception, value of said property being $1,000 or more but less than $7,500. That's a violation of 2913.02 of the Ohio Revised Code, theft, a felony of the 5th degree. Maximum penalty is 12 to 12 months in jail and a $2,500 fine. And on the C case, it's alleged that on or about November 6th, well, let's go through that in a minute. On or about November 6, 2024, that you did in Fayette Township, that you did possess or have under your control a substance, device, instrument, or article with the purpose to use it criminally in the commission of a felony, to wit, a pair of black wire cutters. It's a violation of section 2923.24A2, possessing criminal tools. That's also a felony of the 5th degree, maximum penalty up to 1 year in prison and $2,500 fine. Mr. Hargis, are you currently working?
No, sir.
I presume you would like to be...
The reason I was at Walmart is my house was burned 2 days prior.
Well, hang on. I don't want you to say anything that can be used against you on there. You're not working, correct?
No, sir.
Okay. I'm going to appoint Attorney Luke Steyer to represent you. I'm appointing Attorney Luke Steyer to represent you. He just came in the courtroom. State wished to be heard on the matter of bond.
State would request a $10,000 cash surety bond.
All right, I'm going to go ahead and set bond at $10,000 cash surety. Now, Mr. Hargis, your attorney is going to contact you, and if he wishes to have the matter recalled for an argument on bond, I'll certainly entertain that from him.
I get some rehab or something like that.
And he's going to speak with you about that as well. And if he wishes to have it recalled, we'll have it recalled.
Do you know what day he came into custody, Your Honor?
It looks like the 6th.
Yeah, 6th, so.
Okay. So the 12th or the 10th would be within the 10 days required to have him have his preliminary hearing, and I'm available both days, Your Honor.
Wait,
Apology?
oh, sorry. If he came in the 6th.
Then the 12th or 15th. would
Okay,
be within the
15th,
10
sorry, I
days.
thought you said 10th, sorry.
No, 15th, I'm sorry.
Okay.
10th isn't a court day.
Let's do the 12th.
I'm going to ask that if there's a jailer listening, I'll ask that he be held out for a moment that I can call him when I step out of the courtroom. Well, maybe not, hang on.
Anything else you wish to bring up?
Not at the moment, Your Honor. I'm going to need to speak to him before we can go any further with that.
All right, Mr. Hargis, your attorney's going to call, reach down to you. We're setting a preliminary hearing for the 12th. He's going to call down to you, speak with you about some things, and I'm anticipating that he's going to want the matter recalled for bond, so we'll probably have you back out at some point today to discuss the bond.
Yes, sir.
All right, thank you, Mr. Hargis.
Magic correspondence.
State of Ohio versus Jeffrey Holly, case number CRA 24698 A and B, and Kimberly McCann is on deck.
All right, this is State of Ohio versus Jeffrey Holly, CRA 24698 A and B. Mr. Holly, can you hear me? All right. Mr. Holly's present via Zoom. His attorney, Roger Smith, is present here in the courtroom. State's represented by attorneys for appeal.
Your Honor, it's my understanding the state has confirmed there is a holder that will not be lifted out of the court of common pleas, and they intend to nolly this to the grand jury.
Is that correct, Mr. Hill?
Yes, Your Honor.
All right. Matter will be nollied to the grand jury. I'm assuming both the A and the B case.
I'm sorry.
I'm assuming both the A and the B case.
Yes, Your Honor.
All right. Mr. Holly, your matter is being nollied directly to the grand jury. My understanding is you've got a holder out of common pleas court. And so all of the rest of this case will be headed that direction. And the rest of it, you'll be dealing with over at common pleas court.
Thank you, Your Honor.
Thank you, Mr. Holly. Thank you, Mr. Chairman.
State of Ohio versus Kimberly McCann, case number CRA 24720, and Carolyn Rayburn Slack is on deck.
I was going to say while we're waiting, let's call something else, but she just coming up. All right, this is State of Ohio versus Kimberly B. McCann, case number CRA 24720. Ms. McCann, can you hear me?
Yes.
All right. Ms. McCann, have you received a copy of the charge? I'm going to go through the charge with you and what some of your rights before the court. You have a right to remain silent. You're being recorded, so if you try to give me an explanation, it's being recorded. The state can use that against you, so I suggest not doing so at this time prior to speaking to an attorney. You have the right to an attorney, and if you can't afford one, we can appoint one for you. We'll discuss that shortly. You have the right to have reasonable bail, and you have the right to make a statement through the charges and charges beyond a reasonable doubt. Do you understand those rights? Do you understand those rights? All right, Ms. McCann, it's alleged on or about November 5th, or 6th, 2024, in Fayette Township, you were acting with the kind of culpability required for the commission of an offense, did knowingly aid or abet another in committing a violation of section 2913-02A2 of the Ohio Revised Code, theft, in violation of section 2923-03/2913-02A2 of the Ohio Revised Code, complicity to theft, felony of the 5th degree. Maximum penalty for a felony of the 5th degree is up to 1 year in prison and a $2,500 fine. Do you wish to be considered for court-appointed counsel?
Yes.
Are you working currently?
Yes.
All right. Are you paid hourly?
Salary.
All right. On salary, what do you make per?
It's $20 an hour.
It's $20 an hour. Okay. How many hours a week do you get?
It's up to 40, but like I said, it's salary, so I'm like more.
What's Is an average week 40 hours for you? Okay.
Generally, I don't have it now, because I've been here for 2 days.
Okay. Do you have any dependents? Okay. Well, you technically don't qualify. You make too much to qualify for court-appointed counsel at this second, which means you would have to either hire your own or if you can't hire your own because you find that you have lost your job, then you would be able to come back and request counsel at that time. But as we sit here this second, I can't appoint someone to represent you going forward as far as that goes. But Mr. Hill, you wish to be heard on the matter of bond.
Your Honor, this is a co-defendant of Mr. Hargis who was just before the court, although this is the only charge she has in relation to that is the theft part of it. We would not be opposed to an OR bond, but just to make sure, we'd want to see if, we'd like her to have a drug screen, just to see what her circumstances are.
Okay. I think that is a good idea. Ms. McCann, we're going to have you drug screened before we determine the matter of bond. We're going to have you screened, and then we'll recall your case here shortly, and we'll discuss a bond and what that bond's going to be.
Okay.
So we'll have you back out after we have the results of the drug screen.
Okay.
Thank you.
State of Ohio versus Carolyn Rayburn Slack, case number CRB 24-713, CRB 12-18 A and B, CRB 11-1053.
Okay. This is...
Mayor Rayburn call?
Yes.
Your Honor, this file,
I've actually haven't called yet.
This is separate. This was in the wrong file, so I don't know, this file you still have out here, it's in back, so.
Thank you, Mr. Steyer. All right. This is State of Ohio versus Carolyn Rayburn, but my understanding, ma'am, is your last name Rayburn or is it Slack?
My legal name is Slack. Rayburn was my married name.
Okay. May I ask your date of birth?
5/16/1970. I am the same person.
Okay, I just wanted to make sure of that.
Okay.
Yes, sir.
This is going to be State of Ohio versus, I'm going to say it as Carolyn Rayburn Slack. That way it's referenced. CRB 24-713, CRB 12-18 A and B, CRB 11-1053. Mr. Steyer is present on behalf of Ms. Slack. Ms. Slack is present via Zoom, and the state's represented by Attorney Philip Hill.
Your Honor, this matter is set for pretrial today. I have a single count of domestic violence, misdemeanor of the first degree. My understanding is the alleged victim wishes to have a protective order. I don't know beyond that there's much reason at this time. I haven't had it out. I just got reported to this on Monday. I don't know if I filed discovery or not. Not 100% certain.
Don't see it in the file, but that's not necessarily dispositive of that.
No, I haven't filed discovery yet, Your Honor. So, and I haven't had an offer from the state. I would think we might be able to work on getting Ms. Rayburn out of jail today and maybe setting this for another pretrial. Although I recognize that the state's going to probably be wishing for a protective order. So you understand that if we can get you out, you're going to have to stay away from the alleged victim? And you're able and willing to do that?
Yes, sir.
Okay.
Ms. Slack, do you have somewhere that you could stay that would not be near
Yes,
Mr.
sir.
Curry?
Yes, sir.
Okay. What was the vote? Mr. Hill, what are your...
Your Honor, I was trying to figure out what was holding her in jail because of the charge alone would normally not be something that would require a cash or surety bond, but I don't know the answer to that because I wasn't here the other day.
I think that looking at the file, I may know the answer to that. We've got a 20 CRB 1218 A and B and CRB 111053, and it looks like the allegation was that back in August 24th of 2012, that Ms. Slack failed to appear for a review hearing some time ago. And I'm sure that is why the bond was set with a cash assurance bond at this point.
It looks like she has about $600 or so in money that's alleged to be owed to the court. In the event that she were, and I'm not saying she's making this admission at this time, in the event she admitted to that failure to appear, would the court be inclined to sentence her to the time served for the failure to appear and allow her an OR bond on this case if the state didn't object? And then obviously she would still owe the money and would have to begin to make payments once she was out.
We're not opposed to that, Your Honor. There was a protection order already issued.
Correct.
And that, we want that to stand.
Okay.
But we're not opposed to what
It was issued for a Richard L. Curry, date of birth 2/12/64.
I think that was handled on Monday. So do you understand what the court and the state have said is that if you admit your failure to appear, the court would impose the time you already served as the sentence for failure to appear and would then allow you to sign a signature bond to get out while these cases are pending? Do you understand that? Is that what you'd like to do? So in that case, Your Honor, we'd like to enter a plea of guilty to the failure to appear, ask that the court impose the time served as penalty for the failure to appear, and issue an OR bond that would cover all matters. And then we could come back at a date convenient to the court. This is an M1, so we've got plenty of time. We don't have to rush on this. We can set it out a little bit further.
All right. Is that correct, Ms. Slack? What your attorneys indicated to the court?
Yes, sir.
All right. On the failures to appear for the 11-1053 and the 12-18 A and B, I will sentence you to time served for the failure to appear. Now, on the new case, you still owe around $600 on the old cases. I'll be honest with you, Ms. Slack, I'm a little concerned because you hadn't appeared back since 2012.
I wasn't aware that I had even missed the court date. I will show up whenever you ask me to.
I'm going to give you an opportunity here, and I'm going to let you sign a $2,000 signature bond. So I'll amend the bond to signature bond of $2,500. That means you're going to get out today. You cannot have any contact, whether it be in person, text message, social media, carrier pigeon, don't care. You cannot have any contact with Mr. Curry until further order of the court. In the event that you do, your bond is going to be revoked and you'll be going back to jail. Also, as I'm giving you a shot to appear here on your own, because I don't like for people to have to sit in jail, but this is going to be your one and only shot because you were away for a long time. Do you understand that? All right. So, Mr. Steyer, I don't want to come back too far from now because I want to make sure that Ms. Slack gets out of jail and appears at court. So,
would December 2nd work, Your Honor?
Really like to do it prior to that. Are you
okay?
Either the 18th or the 22nd?
I'm not here the 22nd, but I am here the 18th.
Okay, I'm going to set this for Monday, November 18th. For a pretrial at 10 a.m.
Your Honor, do you want the prior cases set for review on that April?
Yeah, all matters pending. So, Ms. Slack, did you hear the date?
Yes, sir, to appear there in Chesapeake.
Yes.
Yeah, the courthouse across from the flea market.
November 18th, November 18th at 10 a.m.
Now, I have something else that will be of interest to Ms. Slack, and that is that Mr. Curry says that Ms. Slack's friend Jack from Huntington can help her get her stuff from Mr. Curry. He has a truck, so she can have Jack contact Mr. Curry and arrange that.
Okay, did you hear that, Ms. Slack?
Yes, sir.
Okay.
Yes, sir, thank you, I did.
All right, we'll see you back on November the 18th.
Thank you, sir.
Thank you.
State of Ohio versus Thomas W. Ward II. Case number CRB 24719, CRA 24259. And David Barber is on that.
This is State of Ohio versus Thomas Ward II. Sir, are you Mr. Ward?
Yes, sir.
All right, did you receive a copy of your charge?
Yes, sir.
Okay. All right, we're going to go through these charges, Mr. Ward. There are a few of them here, but first I want to kind of advise you of your rights. So I'm going to go through the charges, and then I'll ask you for a plea. You can enter a guilty plea, a not guilty plea, or a no contest plea. Guilty plea means you're admitting the violation. Not guilty plea means you're denying the violation. No contest plea means you're not contesting the violation, but you're not admitting it either. You have the right to remain silent, so if you want, prior to entering the plea, if you tell me things about your case, it's being recorded and it can be used against you. You have the right to have an attorney. If you can't afford one, we'll appoint one for you. You have the right to reasonable bail, and you have the right to make a state prove each and every element of the charges beyond a reasonable doubt. Feel like you understand those rights? Yes. All right. So we'll start with case number CRB 24719. Oh, excuse me, there's a...
He's already got a pending case, so he's supposed to be doing counseling up here.
Yes. CRB 24719. Mr. Ward, it's alleged that on or about November 6th, you did knowingly cause Rachel Ellis to believe that said Thomas Ward would cause serious physical harm to the person or property of Rachel Ellis in violation of section 2903.21A of the Ohio Revised Code, aggravated menacing. That is a misdemeanor of the first degree, maximum penalty 6 months in jail, $1,000 fine. I do see here that there's a second charge, and it looks under CRA case 24259, and it looks like that it's alleged that on or about October 7th, that you failed to appear for a preliminary hearing, and Attorney Luke Steyer was appointed to represent you. So what I'm going to do is, we have Attorney Luke Steyer in the courtroom. I'm going to get your attorney in because I don't want to ask you for a plea on that with you having another outstanding case with an attorney. So Mr. Steyer, I've got Mr. Thomas Ward here. Looks like you were representing him on a felony case. He was in treatment. looks like it was a grand theft. And it was alleged that he failed to appear for a preliminary hearing on October 7th. He has a new charge if you wish to approach and take a look. It's an aggravated menacing.
Your Honor, he had failed to appear on September the 9th of this year. He had finished the residential portion of his treatment, but was supposed to do outpatient after that. He didn't show up to court. That was the last I saw of him until today.
Yeah, the last report that I've got looks like it was from September 3rd.
Your Honor, can I have the case number?
Sure. There's two. There's a CRA 24259 and a CRB 24719.
Thank you.
Actually, Mr. Hill, can you approach? Last report I have, September 3rd, and it says client is not engaged in any services, has missed urine drug screen on 8/27 and 8/28. Client will be sending intention to discharge letters of the third week of those services. Client is not returned phone calls or responding to emails when it's continuing to attempt to reach out to them. So. Yeah, I see. There was a 9th and there was a 27th. And there's no notes from the 9th, but on the 27th it was scheduled. Yeah, that's what I was wondering. And then this new charge. I arraigned him on it, but I did not. In a plea, I was going to run a guilty plea for him. I'm assuming that I haven't done so. I'm appointing you for, since you're already representing him. I've been screened for the bond portion of it and see where it goes from there. Looks like men agrees. I'm not sure.
Is there anyone from Bennett Reeds here today?
They're not here. I can call them though.
Okay, thank you.
Sure. If it's not, they're not. Okay. Yes. All right, so Mr. Ward, I'm going to enter a not guilty plea. I'm going to enter a not guilty plea for you on the 24/7/19 case. I'm going to appoint attorney Luke Steyer to represent you since he's already representing you in your other case before the court. And I'm going to have you drug screened prior to us discussing what your bond will be. So we're going to have you screened.
Any way that I can get back in treatment, like I need some extra help. I do good in rehab, but I went home, got a job, that's where I live, it's at my brother and Rachel's house, and it's just chaos there.
And sir, what I'm going to do is I'm going to actually reach out to Mended Reeds, they were who you were with before, and see if I can get them in touch with you. And then I'm going to ask to then have the case recalled on the matter of bond.
But we want to see where you're at as far as what's coming back in the screen. But our intent would be if they'll accept you back, to put you back in treatment there.
Your Honor.
I have meth and marijuana and probably alcohol in my system. Like I do have drugs in my system.
Well,
And I
okay.
really want some help with drugs.
And I'm gonna contact Minute Reads and see what I can do about that, sir.
Your Honor, I think it's also, and for Mr. Steyer, it's probably going to be important for the court and Mr. Steyer to read the affidavit as to actually what happened here.
I have read the affidavit.
It's a pretty serious situation.
Recognizing that. And I would assume there's gonna be a request at this time for protective order.
Yes.
Now, do you understand that at least for the time being, there's gonna be a protective order entered if you're able to get out of jail?
Yes, I mean, that's completely fine. What was that?
Well, we're not gonna say anything more yet. We're on the record, so don't say anything more right now, but just do you understand it would agree to a protective order?
Right, yes, and that's completely fine.
Perfect. That's all that needs to be said.
That place is evil.
That's all that needs to be said right now, sir. We got you.
All right, well, we'll have you back out here shortly, Mr. Ward.
Thank you.
Thank you.
State of Ohio versus David Barber, case number TRC 182591. 934 A and B. And Michael Rose is on deck.
All right, this is State of Ohio versus David Barber II, case number TRC 182591. Mr. Barber, can you hear me? Yes. All right. Mr. Barber, it's alleged that on or about July 22nd of 2022, that you had failed to appear for a review hearing. Do you admit or deny that you failed to appear for the review hearing?
I don't remember, sir.
Okay. All right. Well, it looks like you were here on an old OVI case back in 2018, and it looks as if you were sentenced on that case, and the court then will set review hearings to make sure that you're paying your fines, doing community service, and the like until it's gone. The allegation is you didn't appear at one of those review hearings, and it looks like a warrant was issued for you back then. Mr. Major, is there anything that you wish to kind of tell the court?
Yes, Your Honor. My understanding is Mr. Barber is being held in Lawrence County Jail on a charge out of West Virginia. My understanding of that charge is pretty significant, and it'd be my recommendation that, being that the fines and court costs are so low on this case, that we would convert that to jail time and let him go to West Virginia and answer the charges over there. I believe it'd be 11 days in jail would take care of these cases, and I believe that he would probably be in longer than that on the charges he has out of West Virginia.
Okay. Mr. Barber, did you hear what Mr. Major had indicated?
Yes, sir.
And my understanding is you were in Municipal yesterday and signed an extradition to West Virginia.
I believe it was Tuesday or Monday, I went.
Okay.
And I signed a waiver.
Okay. If and I'll go ahead and tell you, if you were to admit the failure to appear here in the court here in Lawrence County Municipal Court, I will sentence you, as Mr. Major has recommended, to 11 days in jail. You'll get credit for the time that you've been there already. I will run that concurrently with anything you get in West Virginia, which means if you get every day you serve in West Virginia counts towards your Ohio sentence. And then your case here will be completely concluded. You won't have to pay the remaining fines and court costs. So, do you admit or deny that you failed to appear for the hearing?
I'm not denying anything, I just really don't remember back then. That missed, I thought I had court back then, I really didn't remember.
Okay.
It must have slipped my mind, sir. I had so much wrapped up in my mind. What's going on?
All right, I understand. I'll take that as your admission, and I'm going to sentence you to 11 days to complete the case, to run concurrently with anything you get in West Virginia, and credit for time served.
Sir.
Okay. And if is anybody listening to the jail, West Virginia, he'll now be free to be picked up by West Virginia now. He doesn't need to be held here on this court sentence because it's going to run concurrently. Okay, perfect. All right, best of luck, Mr. Barber. Thank you.
State of Ohio versus Michael Rowe, case number CRB 23-4. And Anthony Giamarco will be on deck.
Oh, here's James. This is right. James Michael.
All right, this is State of Ohio versus Michael Rowe, CRB 23-4. Mr. Rowe, can you hear me?
Yes, sir.
All right, you're Michael Rowe?
Yes, sir.
All right, Mr. Rowe's present via Zoom. Looks like you had an attorney appointed at one time, Sean Stratton. I don't know if you're still technically representing him or not.
What's the name, Your Honor?
Michael Rowe, and it's alleged that it would have been on or about September 29th. They failed to appear for a review hearing. I don't know if you were technically still on the case, so that was...
Your Honor, that was back in 16, I believe. No,
No,
I'm
it's a
sorry.
23 case.
Different Michael Rowe, I'm sorry.
No worries. I don't know if you're still on the case or not on the case.
I don't recall at the moment, Your
I
Honor.
think it's a review hearing issue.
Okay.
I know that he's been sentenced on this charge.
Oh, yeah, they did his review, Your Honor.
And if I may, Your Honor, I was approached this week by his father telling me he was incarcerated in Gallia County. I knew that he'd been incarcerated for a while. He came up for a review hearing, and he missed that hearing due to being incarcerated. So I spoke to the jailer and had them expedite him down here to get him here now. But he's been in the Gallia County jail for quite some time. He has some old charges there that they sentenced him on. I think one of them might have been 180 days, Your Honor.
Okay. Mr. Rowe, do you admit or deny that you failed to appear for your review hearing? I understand you were likely incarcerated at that point.
I think I missed it because I was incarcerated.
Okay. What I'll do is I will sentence you to time served on that. I'm going to set you a new review hearing for once you're released. It looks like all you owe is fines and court costs on this case. Is he still being held by?
No, Your Honor, I believe he's only been held on this warrant.
Okay. And I think on the original case here, he was listed as homeless. Do you believe he has somewhere to?
I believe this is his father.
Here, he's been living with me ever since he got out, close a year ago.
Yeah, I believe he has. I believe he has.
The past caught up with him, and I'm just, you know, I'm the one that come bring him down here, and the one that they have to pay fine and work with police sometimes, and work with some other people right now. He's been doing good, and that's caught up with him. So, yeah, he's got that behind him now, and you're got to go from there.
All right, Mr. Rowe, I'll sentence you to time served on that, and I'm going to set you a new review hearing for December the 9th.
Yes, sir.
At 9 a.m.
Your Honor, I spoke to his dad too, and he's explained to him how he works in the community service and trying to get this case cleared up. His dad's aware of it.
Okay. All right, Mr. Rowe, you'll be released today. And and you have $955 you owe the court. Mr. Major spoke with your father about how you can clear that up, whether it be through payment or working it off on the court's community service program.
Yes, sir.
All right, well, we'll see you back on December the 9th.
Yes, sir.
All right, thank you.
State of Ohio recalls Anthony Gianmarco, case number CRP 24724. Nicholas Bader is on deck.
All right, this is State of Ohio versus Anthony P. Gianmarco, CRB 24724. Mr. Gianmarco, we had you back out and for sentencing purposes after we had drug screening, and there's several things in your screen. So what I'm going to do is, prior to sentencing, do we have any providers that would be willing to speak with or take Mr. Gianmarco to do an assessment?
Excuse me, Your Honor.
I'm not asking for your input at this point. All right. Saw you raise your hand in the back from RRS. Yes. All right. I'm going to have you speak to him, but I do want you to see what was in his screen prior to. Mr. Gianmarco seems to want to tell me what's going to happen and what's not going to happen.
No.
He wants to tell me about it, but I want to I'll give you that opportunity here when we have you back out, but I want you to be assessed first before we ever have that conversation.
All I can say is I'm not.
I don't want to hear it right now.
And the stimulants.
I don't want to hear it. I don't want to hear it right now. I'm going to have you assessed and we're going to go from there.
That's cool. I got 5 years of 520. That's cool.
All right. I'll have you back out.
State of Ohio versus Nicholas Bader, case number CRA 24721.
Your Honor, he has tested positive for only THC, like we had spoken about, that he mentioned earlier. And I believe this charge is only an identity theft?
It's an F5 identity fraud. Someone's being charged.
We're okay with it, no R bond, if that's the next question.
That was going to be the next question. Yeah.
Actually, can I have both of you approach real quick?
Yes.
I would make this try to make sure that there's no problem. Well, let's go ahead and assess. Well, you may want to talk to him about it. Yeah, sure, I have a problem with that. Assess. In the meantime. Let's have a night on Tuesday. All right. All right, Mr. Bayard, I got the results of your screen today. I'm going to order a couple of things. I'm going to give you a $2,500 OR bond, signature bond. Now, in the event that you don't show up to court the next time, we're going to forfeit that money, and when you're picked up, you're going to have to pay $2,500 before you even get another bond. You understand that? You will not have to pay. All you have to do is sign and show up to court, as long as you do that. Now, I'm going to set this for I'm sorry, what was that? I'm going to set this for November the 12th. And I'm going to order you to attempt, and I don't know whether you'll be able to have it done by then or not, but I'm going to order you to seek an AOD and mental health assessment. And if you have it done by then,
Does your court have a recommendation for that?
I can't make recommendations. There's plenty of treatment providers that are around. You're an Ohio resident, correct?
Yes, sir.
All right. There's plenty of providers here in Lawrence County. If you were here in person, I don't know if is there a provider that would be willing to go ahead and do an assessment for him that's here.
That's fine. I can find it.
I can as soon as I get down this week.
Yeah, he'll be in jail for the next couple hours. So.
Yeah, we're going to have someone that's going to call down to go ahead and work on an assessment for you to determine whether or not there's services that you'll need in the meantime. You'll speak with them today. And you'll know who it is. It'll be Taylor. When she calls, you'll be able to.
Okay.
And I'm going to have you back November the 12th at 10 a.m. Yes. And, but I'm going to have you back, it's going to be next Tuesday.
Yes, sir.
At 10 a.m. for a preliminary hearing here at the court. We'll see you then.
I will be there.
All right, thank you.
Thank you for your time.
State of Ohio recalls Justin Hargis at the Lawrence County Jail, case number CRA 24-722 A, B, and C, CRB 24-723.
All right. This is case number CRA 24-722 A, B, and C, CRB 24-723. State of Ohio versus Justin Hargis. We get set bond at $10,000 cash or surety. Earlier, Mr. Steyer was having, I believe, Mr. Hargis assessed for services potentially, and was going to request potentially an amendment to the bond.
Your Honor, yes, I've discussed the matter with Mr. Hill, and I think the state would join in a recommendation to a reduction to a recognizance bond with release only to, in this case, Bethesda, who has assessed Mr. Hargis and is willing to take him, and he is willing to go for inpatient treatment. At that point, we would need to set a preliminary hearing. I'm available Tuesday if that day is convenient for the court. Oh, maybe not, I'm sorry.
Well, our agreement to do this would be contingent on him agreeing to waive.
I thought we had that discussion, we were going to deal with that Tuesday.
Well, I thought we were going to deal with the whole thing on Tuesday, but okay, that's fine. We won't be prepared to have a preliminary hearing on Tuesday. So
He'll be out, so if it needs to be continued, we'll waive time, obviously.
Okay.
Okay.
All right.
We intend for this to go to the grand jury one way or the other.
And I recognize that, but I'd like to be able to talk with my client, not on a recorded line and things of that nature. And if he's out on an OR bond to treatment, I'm obviously going to advise him to be in his best interest to waive. So we can deal with that Tuesday.
Okay. I will amend bond to 5,000 OR. Release only to treatment. with Bethesda. Mr. Hargis, have you ever had treatment before? I know that you've, given that we went to school together a long time ago, I know you've had some drug struggles over the years, and I couldn't recall, I didn't think that you'd ever been given any opportunities for treatment. I want you to understand this won't make the charges go away, but one, going into treatment, it would be something that would benefit you, and secondarily, going into treatment and doing well can only benefit you going forward in these cases. And now the state's indicated their intention to take this case to the grand jury at some point. That we're not here on that today, but I'm giving you an opportunity here because I didn't think you'd ever had an opportunity for treatment. So I guess what I'm saying is, Mr. Hargis, don't let me down, stay in your treatment. Otherwise, the state will nolly it to the grand jury, get a warrant, and
Yeah, I need it.
you've got a pretty significant charge and a pretty good reason to stay in treatment. All right. Mr. Hargis, we'll see you back on Tuesday at 10 a.m. for preliminary hearing.
Thank you, Your Honor.
Thank you. And Taylor, do you guys intend to get him today?
Absolutely, yes.
All right. They intend to release you today. Come get you.
State of Ohio recalls Thomas W. Ward, II of the Lawrence County Jail, case number CRB 24719, CRA 24259. Jonathan Cole will be on next.
All right, this is State of Ohio versus Thomas Ward, CRB 24719 and CRA 24259. We can recall this matter to give Mr. Steyer an opportunity to speak to Mr. Ward.
Your Honor, I've spoken to Mr. Ward. He is enthusiastic about his desire to get treatment. I spoke to Mended Reeds. They are willing and able to take him on Monday. So he's not going to be able to get out until Monday, at which point they can pick him up then. So I would ask for an OR bond to be set with a requirement that he be released only to Mended Reeds for inpatient treatment. I want you to understand, sir, that if the court grants this, that staying in the treatment is going to be a term of the bond, and if you leave treatment, they're going to call and tell the court, and there's going to be a warrant out for you. In terms of when to come back, I don't know if we want to come back, just go ahead and come back Tuesday and check on things, or go out a little bit further than that, but I figure we want to come back sooner than later.
Let's come back on Tuesday the 12th. With the understanding that I don't anticipate, Mr. Ward, we're going to have a report for you at that point, and understanding that, because you're not going to have enough time to be there for them to have a report, but we want to make sure that you did get into treatment and that you are still there at that point.
Yes, sir.
Okay.
I know.
You did well in treatment. This isn't the end of the world.
Like I said, I do well with structure, like it was there at my brother in Rachel's house, that's where I live.
Okay, again, I'm going to stop you talking about things that happened at your brother's house. Please don't discuss things that happened at your brother's house. We are on the record.
Yes, sir, I'm sorry.
It's all right. We got to be careful what gets said on the record.
All right, we'll see you back for both matters on Tuesday.
Thank you, Your Honor.
Thank you.
State of Ohio recalls Jonathan Cole of Lawrence County Jail, case number CRA 24600.
The State of Ohio versus Jonathan Cole, CRA 24600. Mr. Cole is present with his attorney, Mr. Steyer, and the state representative, Attorney Field, and we had recalled this matter. So Mr. Smith have some time to speak to Mr. Cole.
Your Honor, I've talked to Mr. Field. It looks like they're trying to find out, one, if there's new charges coming, they're pending. I believe that they are filing new charges. Second thing is trying to find if there's anybody else who would take him. I think what Mr. Cole needs, and I don't We don't necessarily get any help sometimes from Shawnee to come do evaluations, but they may, if the sheriff's department or the jail requests someone to come evaluate him, he needs to be evaluated. I think there is some mental health issues, and even from his time with other treatment facilities, they recognize he's got some mental health issues that might need to be addressed. So I think what we're going to do is just reset this for next Friday. Is that correct, Mr. Hill?
It's okay with me.
And then try to figure out if he can get in. So I don't know if there's a formal way to get the sheriff's office to do it, or if we can just ask the jailer to contact Shawnee to have him evaluated. So.
Okay. I'll reset the matter at the November 15th, 2024 for preliminary hearing at 10 a.m. And I think that's going to give us some more ideas.
Yeah.
What's going to happen there.
Because I think what's eventually going to happen, all this stuff is going to end up in common police court. So hopefully he's already started some kind of treatment and getting mental health addressed.
Okay. All right, that'll be the order of the court.
All right. Thank you, Ron.
State of Ohio recalls Kimberly McCann at the Lawrence County Jail, case number CRA 24. Anthony Giamarco will be on deck.
All right. The State of Ohio versus Kimberly McCann, CRA 24-720. And this, we were here for the arraignment on that matter. Ms. McCann did not qualify for appointed counsel at this time. We had Ms. McCann screened as a condition of bond. And there was a couple of things. Ms. McCann, are you aware of what came back in your screen?
Yeah, I'm on Adderall. I think it's about Adderall and
Okay. Well, what I'm going to do, because where you've been in jail, I think there's a fair chance that you may not have your position anymore. I'm going to appoint Mr. Morford to represent you. Mr. Morford, if you would approach, I'd have Ms. McCann screened. And originally, based upon her income, I don't believe she qualified, but where she's incarcerated, she may no longer have that position. Correct. If you want to take a look, and she indicates she has a prescription for Adderall. I don't believe that will solve one of those issues, but it's a Kimberly McCann, and it's a Complicity to Theft F5. All right. Mr. Hill, you want to be heard on the matter of bond?
Well, Your Honor, I wasn't privy to the drug results, but I assume that there's something more than what she was prescribed in the results.
I would anticipate that that's the case.
So we're not opposed to an OR bond for Ms. McCann, but we would want her also to be assessed for, to see if she would need to have some treatment.
Your Honor,
I'll let, you probably want to maybe talk to your attorney before you say anything. Because anything you say on the record is being recorded, so I want you to be aware of that.
Okay. Let me call you before you say anything, Ms. McCann.
Okay, thank you.
Okay. What I'll do, Mr. Morford, since you're just being appointed, I'll give you an opportunity to speak with Ms. McCann before we decide the bond on the matter. And I'll let you take a copy of the file. Ms. McCann, we're going to have you recalled a little bit later in the docket again. I'm going to let you speak with your attorney because you didn't have that option before. But I'm going to go ahead and find that I don't think you're going to be qualified going forward, so I'm going to go ahead and appoint an attorney for you. To Mr. Morford, he's going to call you. You'll be able to have those discussions with him, and then we'll recall the case and figure out what the bond is going to be at that time. Once he's spoken with you and has an opportunity, you can explain anything that you were going to explain to him, so that way he makes sure your rights are protected with the court. All right, so I'll be back out shortly.
State of Ohio recalls Anthony Gianmarco, case number CRB 24724 at the Lawrence County Jail.
Your Honor, my name is Mr. Gianmarco has a ABA license.
Okay.
I just got specified.
So the APA holder, one that's not likely headed away, or is that just a?
They don't know the jail.
Okay. All right, this is State of Ohio versus Anthony P. Gianmarco, CRB 24724. We had a screen done, and my understanding was Mr. Gianmarco has been assessed for services, but sounds like there may be an APA holder, in effect, that is holding him currently. I don't know whether that's going to be a holder that they're intending to keep, or they just are holding him because of...
No, hopefully because of this.
Okay. It's one of the jailers there that can maybe speak to that issue. I don't know if it's...
Anyone? Your Honor.
Yes.
This is Corporal Bryant. APA did come by and screen him earlier, but I've not got any word with reference to the holder being dropped. I do know that APA's time in reference to the holder doesn't start as long as he is charged or has a bond for another court.
Okay.
If he was to receive an OR bond with the treatment, I would contact APA and let them know that. At that point, it would be on them whether they're going to move forward.
Release the holder. Okay. All right. As far as treatment goes,
well, Your Honor, when I talked to him, he claims that his mental health medication could cause a false positive for the substances. Based on what he's telling me, he hasn't used in 5 years. He's on Suboxone. I'd be willing to give him a shot at outpatient treatment. But first mishap there, he'd go straight to residential.
well, and I think you had an opportunity to see what was screened for at that point.
Mm-hmm.
I don't know that I particularly buy that, Mr. Gianmarco.
The truth.
So, what I'm going to do is, I'm going to set this for Tuesday for a sentencing hearing. I'm going to order a $5,000 cash as surety bond.
Your Honor, listen,
I've made my
grandma's 73 years old. She can't walk. She needs my help. I'm not. In fact, we're not do drugs. I need your help. I need your help.
I've made my decision.
I can't even get up there and take a shit.
Jailer, get him off the line.
Thank you, Your Honor.
Thank you.
When are we coming back here on Tuesday?
We're going to come back Tuesday and see if his attitude has changed, or he may spend a little more time there. And that's going to be for a sentencing hearing. All right. Thank you for the jail. We're finished.
State of Ohio versus Kayla Nicole Anderson. Case number CRB 24610 A and B. Mr. Stiers.
This is
What name did you say?
it's listed as Anderson inside the file, but it's Kayla.
Oh, okay. That's why I was confused. I have Bowens as the
Yeah, it's
name.
listed as is it Bowens or Anderson?
It's Bowens.
Okay, yeah, on the treatment report that was in the file that was listed as Anderson.
That's my married name.
Okay, and it was kind of hard to read on the outside.
Okay, I apologize, I heard the wrong name and thought it was a different case.
No worries, this is State of Ohio versus Caleb Bowens, case number CRB 24610. Ms. Bowens is present with her attorney, Mr. Steyer. State's represented by for appeal.
All right, I believe the state is going to move to amend the M2 resisting arrest to an M4 disorderly conduct and dismiss the MM disorderly conduct. I think that's cleaner than amending the MM. Maybe it's not cleaner, maybe that's more difficult. I don't know. What we're going to land is just an M4 disorderly conduct, which is not either of the charges that are pending.
Okay, and under what section number, Mr.
But I think that's under the same section as the one on the MM, so maybe it's easier just to do the B case. And we'll agree to the amendment.
Yes, Your Honor.
Even though it's an amendment up.
And our recommendation then is 10 days in jail suspended, and it's my understanding that she's already taken part in some treatment, and we would want that added as a requirement of this case, that she be successful in completing treatment. We'd ask for probation for 2 years.
Okay, and that's under 291711. It's just going to become the M4.
Okay, so I'm amending the A case.
Correct.
What level probation are we intending on this?
Level 4, given that there's a treatment component. On the A case, which is now disorderly conduct and M4 291711, would be a 10-day jail sentence, all suspended.
How long were you in jail when you were arrested? She did spend a night in jail, so I'd ask that she be credited for that day.
Be credited for credit 1 day. Or you can't do it as 10 suspend 9. It'll have to be 10 suspend 10, credit 1. Or they'll take her to jail for a day. Okay. I didn't hear, was there a recommendation on the fine?
We didn't discuss that, Your Honor. I would ask for no fine on this. She's going to have to pay court costs, obviously.
I'll do a $50 fine, but suspend it, or do you pay the court costs? 2 years level 4.
You don't have to pay it.
2 years level 4 probation. As a condition of probation, she'll have to continue and complete her treatment. And we'll set a review hearing date for May the 9th for review. The B case to review has been dismissed.
You're going to have to talk to probation officer. I'll come out and talk to you about the case. I'll come talk to you.
Thank you, Ms. Bowman. Good luck.
State of Ohio versus Vicky Price. Case number CRB 24493, CRB 24451, and CRB 24470.
All right, this is State of Ohio versus Vicky L. Price, CRB 24493, CRB 24451, CRB 24470. Ms. Price is present with her attorney, Mr. Steyer, state's represented by Attorney Phillips.
Your Honor, this matter is, well, these matters are all sort of on hold at the moment. There has been certain filings, and we are awaiting a
result from that file?
Yes.
Okay.
And, well, we've actually gotten the result. We're waiting
But
for...
haven't got the report.
Well, no, we've gotten the report. We're waiting for ABH.
Okay.
So at this time, there's nothing we can really do on this. We've just got to wait ABH. So I guess probably need to keep the case on the docket to monitor, but that's all we can do today.
Okay. Mr. Hill?
Well, Your Honor, Ms. Price and also her daughter are kind of in the same boat because they both are awaiting space at ABH. Meanwhile, they're staying next door to the alleged victims who are scared to death of them, rightfully so, because there have been 3 incidents, 2 of which involve guns. And we have grave concerns. And we've asked the court previously that they be held in jail pending their transfer to ABH. So that's still our position.
If the court, or if Judge Capper had heard that and previously indicated that that wasn't his intention, he has been with the case longer than I have on that, so I'm going to defer to his wisdom on that. I presume there is a protection. Is there a protection order that in the matter?
Yes, Your Honor.
There's a civil protection order and also in this case, no, just a civil protection.
Okay. Well, typically the civil protection orders don't allow for possession of firearms and the like, so that should at least help alleviate some of the concerns, but I'm not sure that there's really anything else I can do at this point, given the factual circumstances and where things are in the case. So we'll go out. It looks like they've been going out about every 3 weeks or so. So let's go out to December 6th.
Your Honor, I'm unavailable on the 6th. I'm here on the 13th.
We'll do the 13th. And maybe there'll be some movement at that point by ABH that time.
If you're still home, you need to come back that day. If you find that paperwork we talked about, just give it to me and I'll take care of it, okay?
All right.
Thank
See you back then. Thank you, Mr. Starr. Thank you, Mr. Hill.
State of Ohio versus Wesley Earls, case number CRA 24276, CRB 24277, CRB 2497, CRB 2488, A and B.
So the State of Ohio versus Wesley Earls, CRA 24276, CRB 24277, CRB 247, CRB 2488, A and B. Mr. Earls present, his attorney, Mr. Steyer,
Your Honor, this matter is, these matters, there's several here, are one with kind of a torturous history. What there was earlier in the matter, a suggestion of competency issue, that never went anywhere due to funding issues. Here, we went on to common pleas court on some other on another matter. Competency was tested there. He was deemed competent. That case has now gone into QRT deflection. He's under QRT supervision for another, I'd say we've been there about a month now. He's got at least another 11 months under supervision. What had been discussed here was basically to see if that's what ended up happening in common pleas. That is what's ended up happening. So I anticipate that the state at this time, oh, here's Megan, you were still here, I'm sorry. And he's compliant.
He is compliant. QRT is doing very well.
I think what we discussed, basically, he ended up in QRT and was compliant. We're going to come back here and check on that, and I believe the state's intention was to dismiss at this time.
So, Your Honor, the charges that we have here are not, I mean, there was a drug charge, but that went on to the grand jury. These charges that are here have to do with aggravated menacing.
Can we approach, Your Honor?
You may. Why don't we do this? Let's reschedule it for a week, but come back, because he's been involved, so I'm sure he knows more about what the discussions were. I don't know, what the discussions have been at this point. Let's come back to November 15th. Yeah, that's what we're doing. All right, based upon some pretrial discussions in that matter and some issues that have arisen, and kind of a disagreement between the state and the defense in this matter as to what was agreed upon, I'm going to continue this 1 week to November 15th, back for pretrial at 10 a.m. That'll allow Judge Capper to come back. He's been involved in those discussions and is more familiar with them than what I am at this point. I think it's a little outside of what I would be able to order for anything today. So we'll come back on November 15th at 9 a.m.
Thank you.
Thank you, Your Honor.
Thank you.
State of Ohio recalls Kimberly McCann from Lawrence County Jail, case number CRA 24720.
This is State of Ohio versus Kimberly McCann, CRA 24720. Ms. McCann is back present on Zoom. Her friend Mr. Morford being present here in court. We were having this matter recalled as to the issue of bonds. Mr. Morford.
Judge, my client is, I believe, a resident of Cabell County, West Virginia. She's gainfully employed at a new business over there known as Number 12 Laundromat. She states that she's in management there and is drug tested regularly there. She says that she has a prescription for Adderall. But nothing else that might lead to those test results.
Okay. Do we have any West Virginia providers for today? Okay. Would you guys be willing to do an assessment on her, and given that she's employed, or potentially take her out on an outpatient basis, given her employment?
Yeah, I can have our team call down to do the assessment.
Okay. Here, Ms. McCann, here's what I'm going to do. So, based upon what you screened for, I'm going to tell you I'm not convinced that Adderall would show up for one of the, I think Adderall could show up for one of the substances that showed up, but I'm not convinced it would show up for the other. But, given that you're employed and the current situation, I'm going to give you a chance. I'm going to give you an OR bond, let you sign an OR bond to get out. Now, you're going to be required to have an assessment done. They're going to call down to the jail to speak with you prior to you being released, and for outpatient treatment. And as part of your bond, I'm going to require you to do some outpatient treatment to make sure that there's not an issue until we come back to court. Do you understand that?
Yes, I understand that. Are they going to be okay with the evenings? Because I work 9 to 5, Monday through Friday, but we're getting ready to take a government job on at our laundromat to doing the government clothing, and we're going to switch it over to doing night shifts, so.
Well, I'm sure that they work with you and have different times and opportunities, but if you want to get out of jail, that's going to be the condition.
Okay.
Otherwise, I can set a cash surety bond for you, and you can attempt to post it or not. I'll give you the option, so.
No, whatever it is, they're going to pay.
All right, so I'm going to order a $2,000 OR bond, and that you're not to be released from jail until until you've spoke with the treatment provider and they've had an opportunity to assess you and set you up for treatment. I'm going to bring you back for a preliminary hearing on November the 12th.
Do you know where the court is, ma'am?
That's pink courthouse?
Right across from the flea market in Chesapeake?
Yes.
Okay.
Yes.
All right, you'll have to be back here at 10 a.m. on Tuesday, November the 12th. Now, I've ordered that you're not to be released until they contact you and get you set up for possible outpatient treatment.
Who's going to be contacting me?
It's going to be OBP is going to contact you.
Okay.
And they've got places in West Virginia.
Okay.
So, once they've contacted you, got everything set up, we'll still see you back on the 12th. But I want to make sure that you're set up for treatment prior to that, so we can stay on top of that and make sure that there isn't a problem. So I'm going to give you some benefit based upon your work history and the like, and let you have another one on. Okay?
Okay.
All right, don't let me down.
Thank you.
Thank you, Your Honor.
Thank you, Mr. Morgan.
State of Ohio versus Jermaine L. Smith, case number CRD 24380. Here at Coach.
Thank you, Your Honor.
Thank you. All right, this is State of Ohio versus Jermaine L. Smith, CRD 24380. Mr. Smith is present with his attorney, Mr. Steyer. Mr. Smith, if you would remove your glasses. Unless they're ocular, they just look like
It is,
sunglasses.
no, those are real glasses.
No worries. And this is state's represented by Mr. Healy, Mr. Steyer.
Your Honor, this is a matter that we have been continuing. He is undergoing some treatment through his federal probation. It's a long-term program, so we're not expecting it to be complete at this point. So at this time, we probably just want to set it back again in a month or two's time to follow up again. But as far as I'm aware, there have been no further problems in the meantime.
Okay. Mr. Steyer, you here December 27th?
I don't believe I am, Your Honor. Let me check though.
Or if there's another date right around in there, or even maybe in the early January?
The 20th or the 3rd. 20th of December, 3rd of January, either of those would work.
See, January 3rd. The pre-trial.
January 3rd. Thank you, Your Honor.
Thank you.
State of Ohio versus Brittany Kazee, case number CRB 24489.
State of Ohio versus Brittany Kazee, CRB 24489. Ms. Kazee is present here in court with her attorney, Mr. Stratton, state's represented by Mr. I had previously in another case indicated, and I don't know if you were part of that, Mr. Stratton, I think she had a different attorney at that point, maybe it was Mr. Steyer, but in that case I had a conflict with Ms. Kazee, given because I represented her in a substantially similar matter in another court. This particular case, though, does not bear any facts that would be remotely similar, so I don't believe that I would have a conflict in hearing the case, but I would leave that to the parties. If they had any reservations as to that, then I would certainly step aside and let Judge Kaplan hear.
I don't believe so, Your Honor. I think we have this case resolved.
Okay.
She's going to plead to a minor misdemeanor, dog restraint. She's been trying to pay on restitution, but they have never received. She's been here like 3 or 4 times to pay on restitution. We wouldn't take any of the restitution money. We had agreed to restitution last time we were here. It's $930.47. She was going to try to pay that, maybe skip a car payment or 2, but I told her not to do that, just to pay what she can and not skip any of her car payment or anything like that. So she's going to pay on that, and I think the state's just going to recommend court costs. So the restitution of $930.47, and court costs. And she's been here a while too, Your Honor.
I saw that.
Called me as soon as I stuck food in my mouth.
Still, she's stepped outside.
Whoever this is. I don't know who this is, but.
Brittany Kazee.
Okay, so one of the things that we need to do is to make sure that the restitution is paid. Now, I realize it's a large amount of money and it's going to take some time, but we need to have that paid.
Maybe we can set this for sentencing, Your Honor, or set it for another pretrial. She can get that paid on the whole.
That's what we would prefer to do, and that way we'll agree to amend it to a minor misdemeanor
At that time.
once it's paid.
Okay.
Like she just told me, she doesn't want to agree to, and not be able to meet that obligation. So, yeah.
I just wanted to state, with it being the money, I don't want to pay it such little, they never see their money, so I'd like to do it in 1 or 2 big and just get it done, because they are my neighbors and I would like to remain the respect and morale there, so.
So what it is, we can set it for sentencing with the understanding that she doesn't have it all paid by that time, that we would set it for another sentencing later on.
I think we just leave the case pending.
Just leave it pending? Okay, we'll just set it for another pretrial then.
Okay. How far out, or Ms. Kazee, how far out would Ms. Kazee need to try to come up with that?
Before Christmas, I mean,
Your Honor, let's do a month, and the worst case scenario is
3 weeks, so.
Well, we'll do a month.
Okay.
We'll do a month, and if she doesn't have it all paid or is unable to pay it all, hopefully the court will understand that we'll
I have a large amount I'm willing to pay now, I just,
How much can you pay now?
I was gonna do 300, but they don't have it in the system.
So who should she pay that to? Would the board accept that?
Why don't you accept it and put it in your trust account?
Okay.
That's probably the easiest way to do it.
Yeah,
I don't know what that means, but okay.
You got it in cash?
No.
All right.
Yeah.
Mr. Stratton, are you here the 20th of December?
Yes, Your Honor.
Okay, I'll set it for December 20th at 10 a.m. for prayer.
Work on that. All right.
After the fair.
I can just run down the gas station real quick and I'll bring it back to you.
I'll be gone.
Oh.
Yeah, I got one case.
I don't blame you.
We'll work on it. We'll work on it. Let's talk about it and see what we can do. All right, don't worry about it.
State of Ohio versus Daniel Turner, case number CRA 24457, CRA 23732.
Thank you.
PRD 1562A and B.
Did you say Turner?
Turner.
Okay. Mr. Turner, apparently, Your Honor, got a conditional release for a medical issue from the jail, and he is not here today.
All right, this is State of Ohio versus Daniel Turner, CRA 24457, CRB 23732, PRD 1562A-B. I believe that Mr. Turner was to be only released to a treatment provider with GPS for inpatient treatment. However, apparently there was sounds like likely a medical issue, and the jail released him for medical treatment. He has not appeared here today as he was ordered. There will be a bench warrant to issue immediately.
Your Honor, I would like to add the RRS did talk to him after he left the hospital. They tried to get him to go inpatient immediately, and he refused.
Okay. Well, I'd like that warrant to issue immediately, and
For this one.
in this case, I don't want Mr. Turner, Mr. Turner having an opportunity to overdose.
Thank you.
Thank you.
State of Ohio versus Lois E. Hill, case number CRB 23568, CRB 23536.
All right, this is case number CRB 23568, CRB 23536, State of Ohio versus Dolores Hill. Ms. Hill is present with her attorney, Tyler Smith. State's represented by Karen Fulton.
Yes, Your Honor, this is a case been pending for a while. She is treating with Prestera. I believe that you're still currently being given medication and all that stuff.
And then we just got a car and we got married, so everything's been doing good. So.
Good.
So, and I asked her to have Prestera fax something down today, but unfortunately, Ms. Hill can't get her medical records herself since she is the patient. I told her they're supposed to release them to you if you ask for them. However, they want a release, a signed release to do that. So maybe we could reset this for another date to try to get an update on how things are going. But it's mostly, she's been treated for a while.
I see that in the file. Ms. Hill, it sounds like things are going well for you.
Yes, sir.
Guys, keep it up. But we do have to get a copy of the report from the provider to make sure everything's going well. Mr. Smith, is there a date that you're going to come back?
It's probably next month sometime, Your Honor. That way, if she has any more, she goes in to see her doctor. In the meantime, she can do that. Otherwise, I've told her she needs to go get it. It's time to release and have them do it.
Okay.
So we can do anytime. December 2nd, I've already set something. We can do that date if you want.
Well, let's go out a little bit further.
Okay.
December 13th.
That's fine.
I'll have you back Friday the 13th.
Oh, God.
I'll be a pre-trial.
10 a.m.
Thank you, Your Honor. Have a good Thanksgiving.
Thank you, you as well.
State of Ohio versus Leonard D. Johnson Jr., case number CRB 23401, CRA 22276, CRB 22278, CRB 17156.
For state Mr. Leonard Johnson Jr., CRB 2341, CRB 2276, CRB 2278, CRB 17156. And Mr. Johnson does not appear to be present. His attorney Tyler Smith's here, state's represented by Attorney Phil Heald. And I've been really encouraged by all of the good reports that I was receiving here. Now I don't see him, but I see his treatment provider here, so.
Evidently, he's at OVP right now for treatment. so-
Yeah, he's doing well with OVP. He didn't have a scheduled appointment. He was going by there to pick up his reports to bring to court, and they decided to see him, I guess. But I told him he needed to get here to court. I mean, he is compliant with treatment.
Okay.
He's been doing well. I don't know. I mean, some of these cases are 2 years old. We've been here for a while. I don't know, when this will be resolved, but hopefully sooner rather than later.
Well, Mr. Smith, what would you like to do on this? I don't, if he's been compliant and he's doing well in treatment, I would be inclined just to set it for another date.
I'd say if we can do that 13th of December date, we can bring him in. Hopefully at that point we can resolve it. I know he's pled to some charges. We're just seeing how things are going. And evidently he's doing well. I think, I don't know if he has any community service or fines or anything. How many?
Who is it?
Leonard Johnson.
No, he's not been here.
He's not been sentenced, though.
He's not been to community service.
He's got some old cases.
He's
There's a
pled to some.
17 case.
He pled to some because he got 30 days suspended sentence. And
He's not been since his last hearing. Let me
okay.
rephrase that.
All right. So he probably has to get some community service done.
Yeah, it looks like he's on the oldest case. It looks like he's got 18 hours of community service, $190 in fines. And that's on TRD 17550. The 156 case, it's 18 hours community service and $190 fine. And the 22 case,
I don't think that was been sentenced.
it's not in there, but it looks like he was sentenced to 30 hours community service, but he may have done that. It looks like he's got continued treatment at ODP, so that may be the only thing left in that case.
I believe that was the felony case. The other one was a domestic violence, I believe, that he pled to and was sentenced on. So that's where the community service and fines would come in with the other cases. But the one that's pending still is the
23, looks like.
Yeah, and so that's the one he's been receiving treatment. So hopefully that'll be resolved.
All right, I'll set it back for December 3rd.
All right, thank you.
Okay, thank you, Your Honor.
State of Ohio versus Tony Walters, case number CRA 23466, CRB 2354, CRB 23467, A and B.
So the case number CRA 23466, CRB 23467, and B, and CRB 2334, State of Ohio versus Tony Walters. Walters is present as attorney Mr. Smith, state represented by Attorney Phil Heald.
Your Honor, this is another one that has been pending for a while. Ms. Walters, I believe, pled to an amended charge misdemeanor. She's been cleaning up property. She has completed her treatment for a while. I believe she's completed community service and paid her costs and fines on one of the cases. So
That's correct. The old 2354 case, it looks like all that has been taken care of. So the CRB 2354, I'm going to go ahead and close.
Okay.
Having task completed.
And she has advised me she's working on getting her
license.
Her permit and license. Because that's one of the hangups is having a vehicle to finish cleaning up. She's moved stuff, but to get everything out. And we've provided pictures over the course of this case where she's done a lot of work. If you saw the property beforehand to now, it has improved. So I don't know, I'm hoping, even if we have one more date and the rest stuff can be resolved at that time and finish with the sentencing and go from there.
How far out would you like to go?
How much time do you think you need to finish? I mean, we can go 2 months out if you want.
Probably 2 months.
All right, maybe come back beginning of next year, just give her a little extra time to finish.
Be okay with
No, we
that.
should
She's
get my
completed
PTO
one, and
back.
on the other old case, it looked like there was only $195 left over on it, so
Okay.
let's go out to January 10th for pretrial defendant's request.
State of Ohio versus Bobby Joe Hoffman, case number CRB 24609. Could be CRA 24609.
And I just want to comment on how unbalanced the gallery is back there. All right, this is State of Ohio versus Bobby Joe Hoffman, CRA 24609.
May I approach your own?
Ms. Hoffman's present, her attorney, Mr. Norford. Ms. Shields representing the state.
Good deal.
All right, negative screens and a really good report. So, congratulations.
Thank you.
Mr. Norford, what saith you?
Full speed ahead, Judge.
All right.
I think she's where she needs to be. I don't think she's real close to graduation, at least.
Looks like it's been a couple of months, but you're definitely on the right track. Let's go out to December 13th if you're going to be here, Mr. Walker.
I'll be here, Judge.
All right.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
The approved trial can
Y'all have a good weekend.
you too.
State of Ohio versus Kathy Knight, case number CRB 24147, A and B.
So the State of Ohio versus Kathy Knight, CRB 24147, Ms. Knight's present, for attorney Mr. Morford, state's represented by attorney Philip Hill. This matter is set for trial here in June, but my understanding is that there may have been a resolution in this case.
We have a joint recommended sentence to present to the court for its approval, Judge. I'm not sure how many days suspended Mr. Hill wants.
We want Ms. Knight to know that the primary thing we want, the number one thing we want is for her to do as good as she can do at Bethesda. And that's really important. But what we're asking for today, in order for us to agree to give her that privilege, is that she would plead guilty to the resisting arrest charge, and we would dismiss the disorderly conduct charge, and we would ask for 10 days in jail, suspended, and probation, and a requirement that she complete her treatment.
Okay. Mr. Orford?
Judge, that is agreeable with Ms. Knight. She would enter a change of plea from not guilty to guilty, Your Honor.
Okay. I see you had nod in your head, Ms. Knight, is that correct? Okay.
Guilty.
All right. I will accept the recommendation as provided. I'll do 20 days jail, 20 days suspended. I'll order the court costs to be paid. $50 fines. 2 years level 4 probation. Yeah. Let's do, I'm gonna set her review a lot sooner, December 27th for review. And on the conditions of community service, or not, on the conditions, under disposition, not going to order any community service.
No community service.
Yeah, no community service, but I am going to order her to complete treatment with Bethesda as part of her probation. And then the B case be dismissed. Continue doing well in your treatment. That was a really good report that I received today, and that's one of the primary reasons that I'm agreeable to do that. And one of the primary reasons that I didn't give you community service to do is I want you to focus on your recovery more than anything else.
Okay.
Before you leave, you're going to need to see the probation department, know what you set up,
Okay.
and then continue doing what you're doing in treatment.
Thank you. Thank you, Your Honor.
Thank you, Judge.
Thank you, Mr. Morgan.
State of Ohio versus Jerry A. Adkins, case number CRB 24640. Jerry A. Adkins.
Had my wife used to be up here too.
I'm sorry.
Okay. State of Ohio versus Shelley Adkins, case number CRB 24641.
All right, we've got two cases. We've got State of Ohio versus Jerry A. Atkins, CRB 24640. And the State of Ohio versus Shelley Atkins, CRB 24641. They are unrepresented by counsel, is that correct? State's represented by Mr. Heald.
Jacob Gregory.
And looks like I've got an update from Harmony House.
No, it's
It's the first pre-trial hearing on this thing. It's delayed 2 weeks at least.
Okay.
Because they did not return the vehicle. And they don't have attorneys anymore. All these call drops. Fantastic.
Okay. Mr. Hill, is your approach? I wanted you to have an opportunity. This isn't necessarily a report, and so I wanted you to have an opportunity to read through it and determine whether you would like a copy for the state's records.
I would like to have a copy of this. And also, Your Honor, I was going to suggest that we have the alleged victims here, next year, and we'll issue subpoenas for them. We'll get things resolved.
Okay. All right. Mr. and Ms. Atkins, Mr. Hill had an opportunity as prosecutor to read that. Any communications that come from any parties to me about your case, I have to disclose to everybody. If you wanted a copy of that, as you can kind of hear. We're not here for a trial today, so I don't have authority to just say, I believe this or that. I don't know what's going on in that case until I hear the evidence. But I think Mr. Heald is what he's indicating is he would like to have an opportunity to try to get to the bottom of what's going on in this case. So that being said, he's wanting to set this for another hearing on another day, send a subpoena to try to get the alleged victim in the case here and to try to sort through some of those things. And so what I'm inclined to do is to grant that request, and I think it'd probably be in your best interest as well. Mr. Heald, how long do you think you would need to accomplish that, or is there a date you would like to come back on?
3 weeks.
Yeah, that'd be
I think 3 weeks is appropriate, Your Honor.
Okay, let's go out just a touch further than that. Let's do December 6th. Because with the holiday, that'll make sure there's a little extra time. So I'm going to set both of your cases back for a pretrial at 10 a.m. on December 6th.
You can run it down on that, over the back street.
December 6th.
But thank you very much, and we'll see you back then.
Thank you.
Thank you.
Thank you.
State of Ohio versus Jordan T. Henson, case number CRA 24696, A, B, and C. Jordan Henson.
State of Ohio versus Jordan Henson, CRA 24696, A, B, and C. Mr. Henson is present, as attorney Mr. Tyler Smith, State Henson. You may.
You mean get back soon? Said now I'm getting back soon?
Did you give a copy of that, Mr. Hill?
Yes, they all got a copy.
I thought you did, I just wanted to make sure. Mr. Smith, what saith you?
Your Honor, it looks like he's just started with OVP, so obviously hopefully it's one that we can monitor and keep here and maybe at some point be dismissed.
Mr. Hill?
We're willing to do that as long as he continues to be compliant in his treatment. It looks like he's starting that way.
Yeah, I'm supposed to have another session today at, it was supposed to be 2:30, but I'm gonna have to call her and see if she could push that back. I didn't know if court would last as long or not.
Understood, no worries. Mr. Smith, you'd have to waive time on the preliminary hearing, but I
Yes.
presume you're willing to do that.
Yeah, so I'll sign a waiver to allow him to continue with treatment, hopefully.
And is there a date you'd like to come back on? So we'll just kind of get started.
I'll defer to you. Do you think 30 days we need to come back
Yeah,
soon?
probably at least a month to give him some time to
Okay.
kind of get established and see how he's doing.
Okay. Is there a date you had? I know we said a couple of things, but I can't recall what date.
The 13th, I believe we said.
We'll go ahead and set it for the 13th, Saturday night you're here. Be a preliminary hearing at 10 a.m. Mr. Henson, keep doing what you're doing. You're just getting started, it's only going to benefit you.
State of Ohio versus Christina Burson, case number CRA 24593.
This is State of Ohio versus Christina Burson, CRA 24593. This person's present referring Mr. Steyer, state's represented by Hill. Burson is one of the better reports I've seen for a while.
Thank you.
Thank you, Your Honor. Ms. Burson's in the QRT program. She's compliant. She's doing well in treatment. I'm wondering if the state might think this is time to nollie this case.
And we are willing to do that.
Okay. This person was in QRT, and I had a note on here of that as well. So on state's request, this matter will be nollied, and this person, good luck to you. Continue doing what you're doing, and
Thank you.
be compliant with your treatment with QRT, and we'll move through this.
Will do.
All right. Thank you very much.
Thank you, Your
I
Honor.
don't know what the means.
She's not coming back, is she?
Not here now. Just keep checking in with Megan. Thank you.
Thank you.
State of Ohio versus Christopher R. Hale, case number CRA 23424, CRB 2487, CRB 1964.
So State of Ohio versus Christopher R. Hale, CRA 23424, CRB 1964. Mr. Hale's president, his attorney, Mr. Steyer, state's represented by Mr. Hill. That's an exceptional report.
So, Your Honor, it looks like, but for the fact that he is on MAT, he would be complete. So, I don't know, but also, while he's on MAT, he's not going to ever be complete. So, I don't know what the state's position on that is, if they want to continue to follow this matter. I know there's some older cases as well, so I don't know what his status on those is at this point.
Kind of run through those with you real quick. On the CRB 2487, there's 84 hours of community service owed and $610 in fines and costs.
Your Honor, if I may, those may not be up to date where he's on.
All those, that was September.
Yeah, I do know he has done some community service.
Okay.
So those are probably not up to date.
Okay.
I've
And it looks like on the B case, these dollars are on the 1964 case, September 20, that's the September 25th update. That was closed, would have been closed out. He doesn't have anything left on him.
Right, I think he's been making progress and kind of closing cases, retiring cases one at a time. So if the state's satisfied on the new matter, and he's been making progress in all measures, it may be possible if we close this today, let him return to the review hearing docket on the other matters, or we can keep going to monitoring further on at least the old cases.
Mr. Hill.
My decision-making ability has reached its maximum today.
Reached your limit today?
I think he's done very well, and so we want to give him credit for that.
Was there an agreement on the case that's still pending? It doesn't look, I can't tell, but it doesn't look like there was ever a plea entered on the 23 case.
Well, that's an F3, isn't it? Yeah. So, yeah, I mean, we looked at this similar to a possession case as far as our willingness to look at a dismissal when he was reached a level of completion that we felt comfortable with. So if the agency feels that he's reached that level, then we're okay with going ahead and nolling this charge today.
Okay. I'll give you your opportunity.
I think-
Let us know. I saw the report's really good.
Yeah, I mean, I agree with, it's from his counselor. I mean, the only reason why he's still is because of his MAT treatment. He's been nothing but compliant, Your Honor.
Okay. At the state's request, then the CRA 23-424 will be nollied. And on the other cases, I'm going to put you back on the review docket for the 9 a.m. docket.
Okay.
Because you've done so well, I'm going to go ahead and move you out into next year. I don't want to go too far out, but let's go out to January 24th.
Thank you.
So now I won't be with you on these anymore. You're not going your own.
Okay.
If you get everything done by then, which I'm not saying you will, but if you get everything done, you don't have to come back. But even if you think you got everything done, I'd suggest you come in one more time and talk to Mr. Cooper or Mr. Major and make sure you're clear.
Cool.
Thank you.
Thank you, Your Honor.
Thank you very much.
State of State of Ohio versus Nathaniel Bulin or Bulin, case number CRB 24-669, CRB 24-670. Set for sentencing.
All right, this is State of Ohio versus Nathaniel Bulin, CRB 24-670, CRB 24-669.
He's done.
It's, yeah, I've got a note here that says inpatient, the VA with GPS, and the VA can transport him there. I don't know if we have any information showing that he's,
Did you say with GPS?
it says with GPS. He was in jail.
We can check into that, Your Honor.
Okay. Let's recall this here in just a few minutes. They still have a couple of cases left.
State of Ohio versus William Gibson Jr., case number CRB 10-1078 A to B, TRC 10-2432 A, B, and C.
All right, this is State of Ohio versus Glenn Gibson Jr., CRB 10-1078 A and B, TRC 10-2432 A, B, and C. And it's like, Mr. Gibson, do you have an attorney currently in there?
Michael Davenport's my attorney.
Okay.
All I have left is community service. I've paid all the fines.
I see that.
We had an issue, Athalia had messed up on my stuff, and we had to clear that up with them.
Okay.
That's how me.
Well, your attorney's not present today. I'm not seeing him, don't know where he is, but there's two options, and rather I can call him and try to figure out where he's at, and then we'll go, see if he can get down here, or, it looks like we're making progress. I could just set you another date. if
That's
what you
all
prefer.
okay. That's what we've been doing.
I'm going to go out, since it's a significant amount, let's go out to January 24th.
Thank you, Your Honor.
Thank you. If you want your attorney present for that, you'll need to notify him to be here, but that's your day.
All right, thank you.
Thank you.
Hold on a second. Your Honor, if I could, we recall Mr. Bullen.
Yes.
I have Amanda Rayburn on the phone here. He is still inpatient. They're not allowed to leave. If we set him another court date, I would give them the Zoom login.
That'll be fine.
And if we could just get another date for him.
Sure. So State of Ohio versus Nathaniel Bulin, CRB 24-670. When we originally called the case, we were looking for confirmation that Mr. Bulin was inpatient with the VA. It appears we have got that confirmation now. So let's set a new date for let's do December 9th.
December 9th, yes, Your Honor. I will make sure they have the login information so he can appear by Zoom.
That'd be great. Thank you, Mr. Major.
You're welcome.
State of Ohio recalls Buddy L. Hardy, case number TRC 23532 ABCD, CRB 23287, CRB 22600, TRC 1870, CRA 1864.
Is it two already? Yes.
All right, this is State of Ohio versus Buddy L. Hardy, TRC 23532 ABCD, and he also CRB 23287, CRB 22600, TRC 1870, CRA 1864. All right, we were here earlier for a review, and Mr. Hardy was then at that time taken into custody and placed in the holding cell. Mr. Hardy, do you have any idea why you are back where you are?
I told you, I didn't know, I didn't feel like I said anything, I didn't cuss you, didn't call you your name, anything like that. I just told you that I had a bad situation, man. And you got me in there. Said I was disrespecting you. And I apologize if you thought that.
It was the way that you said it that came off as disrespectful. And I can tell you, that can happen, but there is a way to communicate that where I understand you've had tough time, and you've been through some things, but on the same token, there's some personal accountability that has to become involved in this. I didn't dig your hole for you. And I'm tasked, hang on, let me finish and I'll give you an opportunity to speak as well.
I'm doing the best I can.
I understand. But, we've got, the situation we've got a 23 case that you've got 60 hours of community service and $825 owed. And I'm not worried about nothing being done on that because in the older cases, the 23-287 case, you're $175. Again, you got older cases, 22-600, you're $275. But then we get back into the 18s there, and there's still, significant amounts of community service and fines and court costs owed. And I understand once you get into some of these situations, it's hard to dig yourself out.
I get sick.
And
2 years old on my foot. I still trying to go in my community service.
I understand that. You had done some, and I saw that. But it's the way that you communicate, it comes off as if you have a bad attitude. And that's not going to get you very far, whether it be with a judge, whether it be with a prosecutor, whether it be with court staff. Now, that being said, I understand that you've had a bad situation, and I feel like you've been punished enough today. So I'm not going to keep you incarcerated. But
I'd rather already go back. I hate it out here. It's too fucking hard for people like me. I ain't got a license to live in Cozy. We would go to walk everywhere. I didn't know about fucking my bicycle or nothing. And just, you feel trapped. Oh, I'm just going in there and feel trapped. No, I don't worry about nothing, dude. Nothing. Don't worry about nothing in there.
Well, again, I don't want to put you in jail, and I understand that you're upset.
I'm ready to go risking the rest of my life because it's too hard out here for someone like me. You don't have a driver's license. You live out the country, and your old lady works from 8 in the morning until 2. Your kids don't leave until 7:40. Where's the time for her to do anything? Where's the time for me to go anywhere? I got to sit at the house and do nothing.
Well, I can tell you that, hang on, I can tell you that the probation office will work with you as far as they have some evening community service options, they've got some different things.
No one's gonna come take me to me service doing that. That's why I was riding the bicycle. But the whole thing you eat, and I keep busting my foot open every time. I'll show it to you right now, and you'll be like, ugh.
I don't need to see it. I believe you that you've got an injury to your foot. You were sitting back here, I was fully planning on just letting you go earlier, but it's the communication style. It comes off as a bad attitude and excuses and the like. And I understand you've got a situation there. I'm not going to throw you in jail because you can't do something because you're injured. I'm not going to. But when you come in the courtroom and you act that way, and you act that way in front of everybody else, you don't give me a lot of options other than to put you in at least for a period of time. But I'm not going to do that today. You're going to be released. You're going to be able to go. I'm going to set you a new review here. Now, I'm going to give you some opportunity. I'm going to set it a little further out so that you've got some opportunity to try to make some headway. I don't expect you to be able to turn around and then dig yourself out of this hole and get everything done all at once, already. I don't. But I do have to see some form of effort, because otherwise I've got no choice but to complete your case by jail time. And there's a lot there, and that'd be a lot of days jail, and that's not going to do you any good. That's not going to do the court any good. That's not going to do me any good personally. It's not going to help anyone. It's not going to be good for your kids. Nobody wants to see that happen. But you do have some obligations here, and you do have to at least make an effort to fulfill them. So I'm going to set you back on January 16th for another review. And I'm not going to put a specific number of things that I want you to do, but I just want you to attempt to do something during that time, period. So you're going to be free to go today. You're going to be released. They're not taking you down to jail and booking you in. We're going to release you right from here and you can go. But, you know, I want you to understand this is serious. So I'll see you back in January. All right. Court is adjourned.